policy but implementation, and our desire for the county action plans. And if there's anybody who is supposed to write about AJS, is none other than Dr. Steve Akoth. Put our hands together for Daktari. Through AJS, is now an advocate, a lawyer and aspiring advocate of the High Court of Kenya. Thank you.
Thank you very much, Ms. Aluda. And I really want to thank the leaders who have spoken before me. My brother from LRF, my sister from Diaconia, my sister from SIDA. Accept again the apologies of Justice Joel Ngugi, who really wanted to be here, and we held conversations about this conference. And I also want to emphasize that this pre-conference is very important for us as a committee. Normally, sometimes I make very long remarks as Fidel Castro used to do, but today I'll make very short remarks. The theme of my remarks, which is based on a discussion with Justice Ngugi, is that justice is achieved through innovations, not monopolies. And I will give you a series of stories as I give this remark. So, the first thing that we as a committee have thought through over the years is to invite all the stakeholders to really think about the division between what we call civil and criminal law. And we always invite our stakeholders to think about a supermarket. Think about the supermarket that you go to often. Some of us go to Naivas, others go to Kmart, others go to Tuskys, others goes to their new supermarkets now also in the various settlements, of course the use of Food Plus and so on. Think about how they organize the shelves. You will realize that not all supermarkets organize items in the shelves in the same way. In fact, there are some items which are classified as construction tools in one supermarket, but if you go to another supermarket, they are classified as farm tools. There are other supermarkets which put vegetables and fruits next to each other. There are others who put vegetables separately and fruits separately. That is a history of classification that we call civil and criminal. It is nothing that has particular scientific, legal tidiness. It is purely pragmatic. It is a choice that is made in a particular history to create a particular convenience of knowing, and therefore it is not permanent. In fact, we know now from the work of LRF that somebody who is charged with a sexual offense, it may well be that the key issue was a land matter. We also know from the work of LRF that somebody charged with murder, the key issue may have been a marital dispute. So therefore, or a contract. So the classification civil and criminal is not permanent, it is immutable. No, it is mutable, sorry. It's immutable. And that's the first thing that we have done as AJS Steering Committee, to convince ourselves that our division is not permanent and irreversible. It is indeed irreversible. And if you look at the hygiene that our legal system will engage all questions of law, all questions of justice, the way they are presented, without saying that this one, because it is criminal, cannot be dealt with out of court. This, because it is civil, can be dealt with through private means. So that division is not part of what from our hygiene. That's very important point to start with. But the key issue in our civil justice system is access to justice. Because is that our adversarial and inquisitorial system is also not about necessarily incarceration and reprimand, but it's also about access to justice. So that if you look at the character of what you call 157 that the member referred to, which is the one that constructs and positions the office of ODPP and gives that office monopoly, or rather a higher hand in prosecution. It does not exclude other actors. That is why our constitution and legal regime now also provides for private prosecution. Why? Because the aim of prosecution is not to have a monopoly of power in the office of ODPP, but to create a definite, clear, hygienic model of having access to justice, Article 48. And I want to give you two examples. If you look at the history of the United States, the right to a jury is a very important right, not of the offender or the suspect, but is a right of the public. It's the public that has a right to participate, to know and determine the decision, such that nobody who should be in incarceration remains in the streets, and no one who should be in the streets is thrown in incarceration. But after the Civil War, it became clear to the American public that the jury system in itself would not deal with the volume of matters that were presented before them. So what happened? There was a waiver of this right, which is very interestingly waived by not this time the public, but by the suspect or the offender. And that is the history of the plea bargain system. So the plea bargain system was an innovation to respond to the post-Civil War situation in the United States. The word plea bargain is nowhere in the Constitution of the United States. Yet, plea bargain is basically the most important mechanism in disposing of criminal matters today in the US. At the same time, if you remember, the history of diversion. Diversion also emerged in the 1960s and 70s in the US as a way of dealing with uncertainties and basically disapproval of outcomes in many of the decisions, because the outcomes did not lead into correction, did not lead into having better people, but led into people basically feeling left out of the society, people left out in terms of a proper justice outcome. And diversion became very useful, especially for children at that time, because it's clear, and we all know, and again, LRF's work has taught us when you look at their analysis of the Boston institutions, that when you expose children to a criminal justice system, often they don't become better off, they become worse off. And therefore, diversion became a tool of pursuing a particular idea of justice. So for that reason, we as a committee have been having excellent dialogue with the ODPP. We are asking ourselves to pose and ask a question. Why is the current Chief Justice and the two previous Chief Justices pursuing the multiple door approach, which includes, among other things, diversion, plea bargain, AJS, arbitration, ADR, mediation, and so on? Because if we don't go back to that question, then we may end up being caught up in little conversations about who is in charge of what terrain, who has what power, who deserves to decide what apparatus, and so on. In our view, and the view of the chair, which I really support, is that the place of Article 159 of the Constitution, and we are all children of Article 159. That is, I mean, all people doing multiple law are children of 159 of Article 159. The place of Article 159 of the Constitution is to invite us as justice actors to ask the question which my sister Jemima has often brought to the table. What is the idea of justice that we want to produce through the various initiatives or actions of either criminal justice system or civil justice system? It is our suggestion that retributive justice is not the idea of justice that our Constitution envisages. Our Constitution envisages relational restorative justice. So how do you achieve relational restorative justice? Relational restorative justice is achieved by taking into account the social context, taking into account the operational context, taking into account the victim, taking into account the prevailing circumstances, and therefore use that to design a justice mechanism. So in a context where, as uh, as has been highlighted by Marie, that the pre-trial detainees constitute the largest number of people in confinement, and one must pose the question, what kind of justice does this give us? So we do suggest, therefore, that a conference such as this one should help us to continuously innovate methods of expanding, methods of pursuing restorative justice, relational justice, one of those methods being diversion, another method being plea bargaining. However, there is one other central question which we must ask ourselves, which is what we are being invited to do in Article 159. What is the philosophy of choosing that method? Why are we choosing diversion? Why are we choosing plea bargaining? We suggest that the philosophy of choosing those methods is inscribed again in Article 159 and has got three limbs. The first limb is that judicial authority is derived from the people. So if judicial authority is derived from the people, it means that the people have got the capacity and capability of being part of delivering justice work. They are not just consumers of justice, they are also really drivers, producers, and so to say, continuous enactors of justice. Because that's the first tenet, that judicial authority is derived from the people. The second one is the place of technicalities. Now, technicalities should not be the prime mover in the process of pursuing justice. In fact, they're useful, the tidiness is useful. Procedure, of course, we know is everything, more so in the practice of common law. However, it should not preclude the substantive justice issue. That's the second limb. And the third limb, and most important, is in every circumstance, we must ask ourselves, whose justice are we delivering? Whose justice are we delivering? This is the essence of Article 159(2)(c) that was referred to by my sister, Ms. Maina. Whose justice are we delivering? Justice for the victim, justice for the complainant, justice for the community, justice for the entire society. This is a core question. Whose justice are we delivering? Now, if you respond to those questions, then you'll realize that AJS, Alternative Justice System, and a policy that was promulgated by through the judiciary really present a framework of reflecting on a model of delivering justice in a way that one reiterates the fact that judicial authority is derived from the people, and two, does not valorize unnecessarily localities, and three, and most important, respond to the question, whose justice are we doing? In conclusion, I really also want to thank Konya, LRF, and above all, CEDA, for supporting the work in Baringo. Coincidentally, in our committee, I'm the liaison person for work in Baringo, and I was in Baringo sent there. Jemima is in charge of the secretariat, and sometimes she gives a lot of orders. That time at an injured leg, but she ordered me to go to Baringo, which I did. And I realized, my colleagues from LRF, that the judge in Baringo seems to be in some sort of haste. It is good haste. She really wants it to be done now. Why? I asked her that question. She couldn't answer it, but I answered it as an anthropologist. As an anthropologist, one field that I like very much, but I don't practice it, is anthropology of medicine, what we call medical anthropology. And one student of mine, I also teach The findings are not yet out. However, what we know is that people don't like to remain for long in the waiting room. Our judge in Baringo is in haste because people in Baringo have been in the waiting room for justice for far too long. They have been in the waiting room for too long. They are getting numb, they are anxious, they are uncertain, and so she wants to deal with it. So I really want to reassure you, LRF, and your colleagues. I don't know if any of your colleagues from Baringo are here because were you in the meeting? Yes. At least I remember her. Yes. In the meeting they were very, the two of yes. Yes. They were very useful. In the meeting we had in Baringo, I was very, very happy. And I must say also that they didn't need to speak for themselves. It is the magistrate who came to me and told me, do you know LRF? Do you know they've been doing ADS work here? Is what they're doing correct? And so it didn't take me long to get an answer. I told them LRF are the innovators of most of what we do. And so what you're suggesting, my brother, Director Esau, is to move beyond the small terrain that you capture in Baringo, because your spread is still quite small. Action plan. Judicial function is not a devolved function. It's not devolved function. However, our chair, Justice Joel Ngugi, working with the Chief Justice, have developed a very innovative model of including county governments in developing a framework for ensuring that there's full promotion ADS practices in the entire county. And I must say that the prosecutor also in Baringo is very progressive, very progressive lady. I know that she's invited here, that she was really excellent. So I want to suggest, Madam, you know, we're with your colleague in Isiolo and Marsabit, support by SIDA, and SIDA supported IDLO to do Isiolo and Marsabit, has really spurred up the movement for justice in that region. So I would like to spur up the movement in Baringo. And I want to request you, Mrs. Maina, to really think of promulgating before you leave here, that you commit that in the next 3 months you will add more resources to LRF, and that Madam Marie is also here. We will reinforce that so that by the time the courts come back from recess, we can take the Honorable Chief Justice to Baringo, launch the action plan covering the entire county of. With those very remarks, I really want to thank, first of all, LRF, to thank Ms. Maina, and to thank Madam Marie for the support that you give to various actors in this movement, because as I have said, this movement cannot be built through a monopoly, built through these multiple actors. Your support to them has reinforced our work and has enabled us to achieve so much that we didn't think we would achieve, and we hope that in the years ahead we'll even accelerate that, so that ultimately we hope that by the year 2027 every county in this country should have an ADS action plan. I thank you very much and enjoy the conference.
Thank you so much, Daktari. Let's applaud him once again. It's my pleasure to welcome Daktari, our Executive Director, LRF, Ms. Irene Maina, the Country Director, Diakonia, and Ms. Marie Ottoson to come so that you can be able to launch the AJS Award guidelines. Ms. Sarah Ogweno represents the prosecution, perhaps can join us, and Honorable Monica Mnyendo. Karibu. Sorry. Okay, so because we have our beautiful faces and we want to get viral, so please move this side. Thank you very much. Shall we all stand up so that we witness this important launch? I want to give a count. Where's the dummy book? Okay. At the count of 1, 2, 3, we officially launched the AJS Award Guidelines. Let's put our claps together. Wow, this is just beautiful, excellent. You can do a group photo, please. Who is the official photographer? So if your phone is less than 100,000, please let's use the official photographer. Thank you. Thank you very much. So as we go out for a group photo, we all have our copies in the bundle that you have. And I want to invite us for a group photo outside. Thank you.
Umetekelezea Nikuulize, ikasema kuna mali unaweza kuweka kando. Ya hapa mbele. Hii kitu. Hii ni hapo. Na hoteli. Ifanye kazi. Haitumiki, itatumika. So, najua kuna cable sijui iko wapi. Nikushikie. Cable inaweza kuwa wapi? Kuna kitu kingine. Nimeweka tu pale kando. Nivo. Unapiga picha? Hapo kwa sawa. Iko sawa?
right now in Makadara and understands why we really need to employ alternatives to prosecution, especially for her customers in Makadara. Let's put our hands together for Sarah Ogweno. We have Faith stepping in for Fresha Gidumbi from NLAS, and is also a member of the NASI AJS committee, works with the National Legal Aid Service, has worked in Nairobi, Nakuru, and is now back in Nairobi, but appreciates why we need to use these alternatives to proceed, especially when we are advising the clients who are seeking legal services, not only at the pretrial stage, to just tell us what the understanding is. They can pick either AJS plea bargaining diversion, and then they can pick either AJS plea bargaining diversion, and then be able to ask them question by question, and then we come back to you to also ask them questions. So it's just a session for us to learn and the benefits that they've seen, or benefits of employing AJS plea bargaining and diversion in criminal justice system. So I will start with Faith. I think we'll just go the way they are seated. We'll start with Faith. Thank you.
Thank you so much, Jemima. Good morning or good afternoon.
Good morning.
Good morning.
Morning.
For those who are new to the National Aid Service, it's a state agency with a mandate to provide legal aid to the vulnerable, marginalized, and indigent people. And when we say legal aid, we mean legal advice, legal representation, drafting of court documents, creation of necessary or legal awareness, and also representing training these plans to self-represent in court. And when we come to context on how we have interacted with AJS and the alternative to trial, I can say that the National Legal Aid is fully implementing AJS in doing our work for legal aid. How are we doing this? When you look at the structure of the National Legal Aid Service at the moment, most of the cases that we receive mostly cover civil matters. But how do we now address these cases but not going to court? What we do is we have established a model in the office where every case that comes to us has to be assessed, and before referring it for drafting or any assistance in court, we refer the same for mediation. So mediation is the first contact for every matter that comes to the National Legal Aid Service. Now, on criminal matters, I know we have not really been in the space, or we have not been heard in matters of criminal law, but we know the role that we play in criminal matters. And this we have extended to going to prisons, various prisons in the country, and about legal aid and how we can be able to assist the accused persons or the people in the prisons. And this we borrow from the Act, which gives NLAS the mandate to work with the people in custody through the in-charges and ensure that those who require legal aid can be able to come to NLAS, and also the mandate that is given to the courts that when an accused person who is unrepresented appears before court and they need legal assistance, they also have the obligation of ordering or requiring NLAS to provide that assistance to the vulnerable person who has been brought to court. Now, what is the key role of legal aid in assisting and assuring that these vulnerable persons are able to also get or benefit from these policies? And one of the key things when we look at legal aid, we look at access to justice. And whose justice is the question? Who this vulnerable person, what is justice to him? Sometimes justice to him does not mean going through the trial process. Maybe they just need the other party to apologize for them, and that's it for them, or to pay them whatever maybe they suffered in the offense that they committed, and then the case for them, that is justice for them. So we assess or talk to the vulnerable person, be it the accused person, and understand what they want. Upon doing that, we ensure that we do or provide legal aid on the basis to ensure that this person gets satisfaction at the end of the day. And how do we do it? Because we are not fully yet constituted to appear in court for criminal matters, we have a team of pro bono advocates who we refer matters to them, and they take up cases to represent these accused persons or anyone who need assistance in court. The other thing that we do is that we have networks of legal aid providers cutting across all the regions that NLAS has offices in. And in these networks, we are able to train them on legal aid. We are able to train them on the various aspects of plea bargain and diversion. Of course, we collaborate with the other actors. And when now they go to the community, especially the paralegals, who I can attest that we have worked closely with LRF in the county that I was before, Nakuru, Gashisho. I think we have done a lot with her in prisons and also in the community at large by ensuring that these policies get to the people, because access to information is key for them to understand and how they are able to deal with their cases and now get assistance or have an idea on what to do when they are faced with these challenges, or when now they decide if they want to take plea bargain or not. The other thing is that we have a collaboration mechanism that is cutting all across all the actors on access to justice, and this mechanism is more of a referral pathway. And this referral pathway, we work closely with even the police stations, the chiefs, the county commissioners, in the event that they come in contact with any person who needs assistance, legal assistance, and they are not able to reach to any other person. They have our contact lines, and we are able to be connected with that person, and that's how now we are able to come up and assist this person. And yes, we are advocating for alternative to the trial process, because we know a trial process may take long, and sometimes these offenses necessarily do not need to go through the trial process, and we are advocating for this plea bargain, diversion, and AJS for these cases to be dealt with in a more expeditious way. So I think that is what I can say about legal aid. And the only challenge that mostly we face is about funding, because now we need a lot of funding to expand to every place in Kenya, because that is our mandate as per the Constitution and as per the Legal Aid Act, to reach to every person who needs our assistance. And that has been our main challenge. However, we have tried to bridge that gap by collaborating with these actors who have a bit of funding in the respective thematic areas, and we are able to work with them to ensure that we give people access to justice. Thank you.
Let's appreciate Faith. Thank you for highlighting on the role of legal aid and what you've been doing, and your interaction with the criminal justice system. Sarah?
Good morning, everyone. I come from ODPP, and it's best to understand the role of the ODPP. Article 157 of the Constitution gives the ODPP the only body the mandate to make decision whether to charge or not to charge. So no one else is vested with such a power. And what does it take when we want to charge or not to charge? I know a lot has been said in the recent case. Let me just talk about it because it is in the public domain. The case of Albert Ojuam, and why some people have not been charged, while others have been charged. So that is the mandate of the DPP. So, in order to charge or not to charge, what are some of the considerations that the DPP looks at? There are tests. We call them the tests. The tests are things that we put it on our weighing scale. What the case is about, the facts of the case, the evidence, which are in form of exhibits, and whether documentary or the forensic one, and also the information if the suspects or somebody who is suspected to have been part of it, uh, that crime. What is this person saying? And what is the person complaining saying? And what are the exhibits revealing at the end of the investigation as or during the investigation? So the first test is called the evidential test. So the evidence that put in totality gives you the evidence. You are yet to go to court, but what has been collected? So that collection part, that is the evidence, which we call the evidential test. So what does it reveal? Does it show that what has been complained about is not supported by what has been gathered? Or does it suggest that what the pieces of information that has been collected points to one person and exonerates the other? So that is the test, one of the tests that we look at. The second one is about the thresholds. These thresholds, what does it really mean? Sometimes, yes, what has been collected is not still adequate. You've only collected part of it, and there's some other results that you are waiting for. What are some of these results? Maybe there was the call data that is yet to be retrieved. There was the CCTV yet to be retrieved. There could also be forensic, the DNA, and many others. Postmortem, yes. Maybe you're also waiting for it. So those are some of the tests that you are waiting for, or the results that you're waiting for, or you are yet to get. Or sometimes a witness has been mentioned. You are yet to record the statements of that witness. So the threshold, ile tunasema nusu mkate, bado haijapita hiyo, ama sometimes hiyo ratili iko vipi? I'm told there's some people here who don't understand English. So let me just do a bit of a mix. Hiyo ratili, hizo vitu zako zote zile zimekusanywa kwenye file. We deal with files. We just don't deal with information which is out there. The file as it is has the file that has been compiled. If you put it on a weighing scale, and weighing scale means there has to be a particular offense that has been complained about. The ingredients of that offense, if you look at, for example, the ingredients of assault, there has to be the grievous harm or a harm. So this harm, what has been collected, does it show that there was a harm? Amba ni ile tu, somebody's complaining and there was no harm. The second thing is, I'm just talking about the threshold, based on the ingredients of each and every offense. So the second ingredient of assault is who did it. Suppose there is that part of harm. The question is who did it. So if you are not so sure about who did it, you cannot really proceed to charge, because if this one says no, this person fell down, and the person complaining says no, I was assaulted, or it is so and so who beat me up. You see, those are conflicting information. So we must be really sure. So that is the threshold. Bado ijapita, the evidence is not overwhelming. Bado iko hapo, in a hang. Then we also have the public interest, the test. So in this public interest, the case that I have cited, the public interest, it is about the perception of people in the society. Is it a small section, or is it everyone in the society talking about it? So that is now the public interest. So what is the perception? It's all about the perception. So suppose we take this direction that the public wants us. What will be the impact? Or suppose we fail to act based on that perception. But you see, perception alone does not really give you the results, because every case has, or every offense has its own ingredients. You cannot parade the whole country to come and talk about, this is what I know. Some of them are not even witnesses, but they're just talking, and you hear it everywhere. So those are the tests that the ODPP has to put into consideration before making a decision to charge. As at that time of making a decision to charge, there are so many options that we also look at. If it is a case that ile evidence bado ina hang, what do? Do we charge? Sometimes, yes, we charge, saying whatever is remaining, suppose this comes out, it can easily now give me the 100%. Or suppose whatever has been collected, even if it does not give me this, yes, will we have fulfilled the public interest? Because sometimes you need to act so that iwe funzo kwa wengine. So that's why sometimes we invoke the public interest. Public interest does not really mean that you are going uh, to prove your case beyond any reasonable doubt. You use that public interest so that iwe funzo kwa, we use it now to teach a lesson or to pass a message. At the time of making that decision again, what are some of the most probable? How do we move forward? Sometimes you find, yes, this is a very rampant offense. Do we divert? Now the diversion part of it. Diversion is where you don't take it to court. You maybe say you can solve it in the community, you can solve it in your household, you can even use the church, what she was talking about as the mediation. So, how do we move from here? What if, yes, you can see this is a husband and a wife, or this is a child that is involved, a truant child who the parents want to use now the criminal justice system. Are we going to be part of it? Sometimes you look at all those factors and say, no, let us give this person a chance. And how do we give this person a chance? We don't take to court and we now divert. So diversion is lile process, yeah, atukupeleki kotini, but we sometimes it's just about maybe all you needed was either mediation, counseling. Sometimes what you needed was maybe just to offer an apology or even to compensate. There was some money that was lost. Somebody says, give me time and I'm ready to pay. So why do you take that matter to court? Well, the parties are ready to reconcile. So not all cases that come end up in court. No, some we look at it and say, this is a case where parties can resolve. You've been friends for a long period of time. I have lent you my money, 10 million. The figure, let me use the figure that Madam Jemima had talked about. I have lent you my 10 million shillings. You've not paid. I have come to you several times, you're not ready to pay. So by the time I now take that decision, asking me, can you give me some more time? Can you give me some more time? I should not be in a rush to take you to court. I will give you that time so that you sort it out. Because at the end of it all, when I take you to that court, the person whose money the person who lent you money will lose. Once she will lose in terms of coming to court so many times, and also the money part of it. So that's how the depression will also kick in. I am coming to court at the end of it all. You see, even if this person is convicted, will that person return the money? No. So you will also allow dialogue and reconciliation to take place. So that is about diversion. But diversion is very, very particular. Cases where you can see, yes, you can do reconciliation, you can do counseling. Diversion itself talks about child offenders, the Romeo and Juliet, the age. Even if the children are involved in the sexual encounters, Zilas are 15, 15, 16, 16, 17, 17, 18, 18. Of course, the age of carnal knowledge starts from the age 12. But this age 12, we as parents, sometimes we have failed our children. They see us, and sometimes they see whatever is taking place in the social media, so they also want to experiment it. Will you condemn this child by taking them to the trial process? It does not really help. What happens? We don't bring it to the court. Yes, this is the file. So we will be asking what would be the best method to do it. How about we involve the counselors? Mostly it's about counseling so that they also understand that whatever they had done, it was wrong. But that is just for the Romeo and Juliet, which they're classified as Romeo and Juliet under the Sexual Offences Act. And that is a decision that came from the Court of Appeal. Because the Court of Appeal realized that so many cases of such a nature were happening. And a number of our children, both girls and boys, mostly it was the boys who were going to prison. The girls who at some point were the ones seducing or making those approaches were left out. So it was also one way of ensuring that the society rehabilitates our children in the best way possible. Diversion still, we also use it for elderly, somebody who is 80 and above. You know, instead of this person going to prison and then going to die there, we look at the offense. What offense has this person committed or is alleged to have committed? Do we have sufficient evidence? So instead of sending this person to go and die in prison, then we'll be asking, how about we ask the parties who are involved, the ones who are complaining about this person, to also just have a round table and maybe instead of coming to court, they can solve it. So the elderly, that is under the category of that diversion. So I've talked of SOA, Romeo and Juliet. I've talked of the elderly, and I've also talked of situations where somebody can easily just give an apology or counseling or even that compensation. So let's now move to the other category. Yes, we have made a decision. We are charging. Yes, I have charged. So in diversion, we are saying there is sufficient evidence. There is enough evidence, but we look at it in terms of 1, 2, 3. And then we are saying, yes, even if we are to go to court, I know we would prove it, but let's give these people a chance out here instead of torturing them through the trial process. The next phase is there is sufficient evidence. Yes, I have made a decision, I have charged. What do? We are in court. So these courts, we will proceed with the hearing. But because we have an alternative, so instead of bringing all these witnesses and you take 2, 3 years, bringing witnesses one at a time, we now resort to, we come and tell you, yes, there is something called plea bargain. And we are here to talk about these alternatives, the plea bargain. So how does this plea bargain work? You see, it is the accused, this is now an agreement between the accused person and the prosecutor. Those are the parties to it. The courts are not supposed to be involved in the agreement. The court, once we have agreed and we have signed, then that's the time we tell the court, yes, we have this agreement, which is a plea bargain agreement. We are here for adoption. So that is the stage where the court gets involved. But during this plea bargain negotiation, how does it really work? And who is supposed to approach the other? We, the prosecutors, sometimes we don't want to be seen to be the one approaching. Why? We end up being accused because somebody will tell you, if you knew you can do plea bargain, then why did you charge? Of course, we're charging because of the evidence, but we now tell you maybe silently, you can do a letter for us because plea bargain is supposed to be documented by way of letters. See, mambo na, I have talked to so and so and we are ready to do a plea bargain. There are processes. One of them is that letter writing. I can do it, yes, you can also do it. But there are some cases that we can see, yes, this is a proper case of plea bargain. Of course, we are not supposed to hide the facts from the other party, especially that accused person. So we are supposed to also disclose, yes, during that pre-trial conference, that this is a case for plea bargain. So it's upon the accused person to accept or not to. But I will not be insisting that we must do plea bargain. This is a case for plea bargain. No, I'll just be looking for my witnesses and we shall proceed. Once that negotiation starts, there is a document, there is a form, there are 2 forms. There's a form for the High Court, there's also a form for the lower court. So, what are supposed to be contained in this plea bargain? It is the summary of the facts, what the witnesses wanted to come and say. Each witness, but you don't say this witness was supposed to come and say this witness is supposed to come and say this. No, it's just a summary. What is the case? What is the case all about? The summary of that case. If somebody was taken to the hospital, yes. Do we have those documents? Yes. Were the photographs taken? Yes, these are the photographs. Were these exhibits taken to the forensic, maybe the call data or the government analyst? Yes. Do you have those reports? Yes. That is a summary of it. So it must be reduced in form of writing the summary. What is this about in short? So that is what that plea bargain is all about. And so who prepares this? It's supposed to be the state. Because the case belongs to, it's the accused person who is charged, yes. There is somebody who went and complained, yes. Ultimately, who made this decision? It was the state. So it is the state that will prepare that summary and exchange that document or send it to the accused person and his representative. So they are supposed to go through, checking each and every fact. Is it true? Is there something that has been left out? Is there something that has been exaggerated? That is now the negotiation. So if there is something that this accused person wants to add, he wants something to be removed, he wants something to be, that's a kind of amendment. So we are also looking at it by the facts or what that witness, maybe if there was a part which was the information which was not available. So we still come back and look at the file. The amendments, the accused person wants us to remove this part, he wants us to add this part. What is the impact? Suppose we went for full trial. Would this bit have come out? So those are some of the things that we are looking at. So if the accused person, yes, agrees, yes, this is how it happened, the summary of it, he signs and his advocate also signs, and then the state also signs. Once that document has been signed, of course, it has to be dated, and then we file it in court. On the date when parties are coming for adoption, there has to be the judge or the judicial officer saying, yes, I have seen a plea bargain document has been filed here. So accused, is this the position? Yes. State, is this the position? Yes. Did all of you sign? Yes. So the court has to confirm that the signature of the accused, and if the accused has an advocate, it must be signed. And if the accused was a minor, do we have a guardian signing? Because minors don't have capacity. So we have a guardian saying, yes, I am the one who has entered into this agreement on behalf of this minor who does not have capacity. So we have to look at all that, or the court has to look at all that. And then once the court is satisfied, then the accused person will be told, yes, I can now see. And you say plea bargain is just about reducing it from that. It must have an alternative. Every offense must have an alternative. So you cannot talk of, we are going for a plea bargain, yet you maintain the same charges. So you go from that big offense to a small offense. In real sense, every offense that has an alternative. So you go for that less offense, that alternative, so that you drop the main offense and you say, I'm ready to plead guilty in this smaller offense. I just use the layman's language, the smaller and the big offense, but that alternative. And so the charges will have to be read afresh, and then a new charge sheet or information will have to be read afresh, and then he will now say true. But the moment this accused person also says not true, you see, that means that agreement cannot go past that, because in essence he's saying, I didn't do it. So even if I have signed here, take what I'm telling the court before, or what I'm telling the court. So take my word for it, I didn't do it. So that is how it will be revoked at that stage. For somebody who says I didn't do it, the answer is not true. So we have no business proceeding. And at that point, even the court has to stop. Stop during plea taking. The court can also stop during mitigation, where somebody says, I didn't do it. The court has no business proceeding with this, because the court has the final say when it comes to entering a plea of guilty, convicting, and also sentencing. So it's a very beautiful document. You see that those are just processes, but are there challenges? Are there bottlenecks? Yes, we have this document. We have Article 159 of the Constitution nicely recognizing alternatives. We also have Section 137 of the CPC that talks of the rules on, talks specifically about plea bargain. Then we also have the ODPP guidelines on plea bargain. But when it comes to implementation, yes, what are some of the challenges that we get? One of the main challenges is about the guidelines together with the CPC 137 talks of you must inform the other party. Accused is ready. Yes, I did it. Informing the other party means the person who had complained against this accused. This is where the main problem comes in. We are not supposed to really seek their consent informing them. The issue is, are they ready to be informed? And you say informing, you just don't do a letter and say, I have informed this person. No, you must create a forum. We call them the case conferences. Some of those people who had complained failed to turn up completely. They failed to come to that conference table. Others refuse to even listen to you. We have called them for those so that we can inform them. Others just refuse to completely listen. They will even walk out. Others become quite emotional. Others don't even want to be part of it. You see, so when you also have a form saying that I have informed them, the issue is, is the other party adequately informed? So that is one of the major problems. And we find judicial officers want to be very sure that the person who had complained was sufficiently or adequately informed. Sometimes we end up revoking those agreements, even if they have been signed, because the other party says, yes, I am the complainant, but I was not informed. Remember, you've been together in a round table, you have talked, they have signed for you that form, but they're saying, I don't even know who these people are talking about. I don't know. So again, we are not really seeking the consent, but the keyword is inform. That part of the rules and also the CPC. This inform is a very, very big bottleneck.
Okay, thank you. But we'll come to the challenges Yeah.
Okay.
So you can send someone, but there's a question on challenges.
Okay. And since we will be talking about the challenges, maybe we will stop at that. But that is the whole process of the plea bargain. So having rules, having guidelines, and having the CPC. So let us focus more on the challenges so that we give breadth to the documents that we have, instead of now just keeping quiet while people are suffering out there. Thank you.
Okay, thank you very much. Let's clap for both Faith and Sarah, and thanks for highlighting on diversion and how plea bargaining is working, and also articulating on Article 159, which talks about the alternatives to court, and how the need. Also, you've touched on a few challenges that you face, but we'll come to that. And at least people understand, appreciate how plea bargaining is working, especially because diversion is easy, issuing apologies and counseling sessions, and you've given the examples that we have. But the bottlenecks that we have in the room is about the challenges and how we can be able to convey the challenges. We can keep it short. Aru, thank you.
Hamjambo. Sisi wote tunaelewa Kiingereza ama tuendelee Kiswahili?
Tutaweza zungumza zote. I know my Sarah has a problem with Swahili. Yeah, I think she went to the US and forgot some bit of Swahili, so yeah. But wewe ni mtu wa Tanzania, unaweza kujaribu.
Sawa, hamjambo. Nitaanza kwa Kiingereza alafu nitaswitch. Sawa sawa. So Legal Resource Foundation Trust is a civil society organization that works for the under-resourced persons. And as you can see from our name, Legal Resource, we are a resource. Tunaleta hiyo haki pale mashinani na kuwasaidia mpate hiyo haki. So kwetu sisi tunajiuliza, haki ni nini? What is justice? Justice is relative. Today you'll step on my feet and I'll say, I'll smile at me and I'll be okay. I'll forget whatever you've done to me. There's someone else will say, I need you to wipe off whatever you left on my shoe. So justice is very relative. And for us, we are happy that alternative justice systems, when we started them or we piloted them in 2008, it really offered the communities, ilipatia wananchi nafasi ya kutafuta ile haki ambayo inawafurahisha rohoni mwao. Nikija pale nimekuibia shamba ama nimepita mpaka wa shamba, nataka unirudishie mpaka wangu. Nikirudisha uko sawa, umepata haki, hujapata, nimepata. So alternative justice system ama kutatua mizozo njia mbadala inasaidia kumhakikishia yule mwananchi aweze kupata njia nzuri ya kuweza kutambua haki yake na kuparticipate kwa ile process ambayo inaleta ile haki inamfurahisha yeye mwenyewe kwa roho yake. So kama Legal Resource Foundation Trust, we are happy that we were able to champion AJS in this country, and courtesy of the first support you are getting from the Swedish Embassy through Diakonia, we were able to pilot these models. We are good. We're happy that the models have been anchored in our constitution. We are seeing them in a policy. There's a policy that has been given to you under the different documents you have on the table. It is anchored there. It is giving us opportunities to go directly to those elders where you feel that is where your justice can be served. You can also come to the court. That is where you want your justice to be served. But again, it takes back that power to you as a people to make a decision on what you feel access to justice is for you. So as Legal Resource Foundation Trust, we are happy that the AJS is working. We started with them as the autonomous platforms in the communities where elders walijiconstitute huko mashinani. Mnaamua sisi ni Wakikuyu, tunaenda kwa ile yetu tunaita nini? Wakikuyu tunaita kiama, si ndio? Kwa Wakamba tunaita kiama bado, si ndio? Kwa Wameru tunaita Njurincheke, si ndio? Hapo ndio tunapata haki. So ikaanza pale, lakini tukaangalia through the policy, we were able to now rationalize them. And we came up with 3 models. The autonomous platforms where elders operate in situ without influence from any other person. We have the court annexed, where we're now working closely with the court and we're seeing elders here who are going to tell us what they're experiencing in that process and how that has really sent back to the community in as justice to the communities that we serve. Then there's the third one, which speaks to the third party, where we are engaging Legal Resource Foundation Trust, probation, children department to help you resolve. So many people hapa nje wako na cases za nini maintenance. Where do you go? You call your spouse, you go to the children's office. you're able to sort your issue there. So access to justice for us is very relative, and you want to give the communities that opportunity to participate in that process of getting justice, but also determine what justice is for them. In as much as when you go to court, the court will determine the justice for you. Watasema umeibiwa simu, sheria inasema tunafunga miaka mingapi? Mitatu. That is justice for the court, but that does not really mean that you have gotten what? Justice. And I'll echo what Daktari said. We need to make it more, practical for the communities and the people who really want to partake of this particular justice that you're talking about. And of course, there's a lot of benefits from this AJS process, and you can see we've highlighted here that we have a banner specifically for the benefits. It decongests our facilities, it is accessible. And you've seen from the stories we've received from Diakonia, Baringo is very far. It's far-flung. People know, actually they say, Kenya ni pali pengine. And you've gone to places like those who say, umetoka Kenya, what have you brought from Kenya? So you can imagine this person, they've not accessed the governance process, and you have the devolved organization, the devolved governments. But still, they have no roads, there's no water, basic needs. So what about access to justice, which is very, far-fetched for this common man? And so bringing AJS to this community is really a plus. And that is why, even as we launched the model in Tiati, we were able to get at least a case that was resolved, and people were happy that yes, justice is finally coming closer to them. They'll be able to work around and be able to get a justice that fits them, appeases them, but also enhances the cohesion in the community. Because right now, as you can see, the communities of the country is so divided. So how do we bring our communities together? And the story that began when we started the AJS conversation, it is in 2008, during the post-election process. During this time, people were fighting. And in Kipkelion, it's a cosmopolitan community, but they were fighting. They burnt their neighbors' homes. But through these peace committees that we established at that particular time, they were able to appease each other, reconcile, and help each other, come back, catapult back beyond the conflicts, beyond the destruction that happened after the elections. And as a result of that, we felt this is a good model for us to convert them into AJS platforms that are now currently being used to do what? To resolve dispute. And we are here to hear stories from the beneficiaries. I won't talk for them because they're here. They'll tell us what this has worked for them, how they've really felt justice as a result of the work that you're doing. And yes, AJS is the way to go because it gives the power back to the community, back to the people as per the constitution. We derive that power from the people. So we are taking it back to the communities, to the people, for them to make a choice of what kind of justice they want, and AJS gives us that opportunity.
Thank you very much. Let's clap for Mildred. And indeed, as one of the pioneers of AJS, we can see great milestones that IRF has done in Isiolo, Kitui, Baringo, Kericho during the dealing with the post-election violence, and how to just use this out of court to bring communities together as part of cohesion and healing, and empowering the community to be able to deal with justice in their own language. And you've just enumerated the way different communities, Kikuyu have their own way, the Merus have their own way, Boranas have their own way, and indeed, it's important to empower the communities. It just talks about Article 1, the sovereignty of the Constitution, and sovereign power belongs to the people. Yes, Corporate Justice, tell us about Kitui. Mtomo, sorry, yeah.
Good morning, everyone. I'm Corporal Justice Gitonga, working with the Kenya Prison Service, Mtomo Prison. I will talk about the AJS because that's where major I work. Started working with the Legal Resource Foundation in 2021, and so far we have reconciled about 180 cases, 8 cases to our fund. However, there are those major cases, but the root cause just a pet case, as the doctor said. I want to give an example. At the time I was working in Nyeri, one old man was brought a case of defilement, but the family conspired to take this old man to prison so that they can take the land. That old man died in my eyes in hospital. He was 79 years old. Stayed in prison for 2 years and died. So it pained me a lot. So the same is happening in Kitui also, because the land identification is so happening in Kitui. Those cases are so many in Kitui, so I don't know if the legal fraternity will help us diverge on those cases. The AJS has helped us as Mutomo prison concerning 180 cases of congestion, cost effective. Because prison service, I think we spent 2 billion per quarter, in terms of 3 months, in feeding only. We have not talked about the medicine, facilitation to court. For example, in Kitui, you have 5 courts. So the person from far area to Mutomo is about 400 kilometers. So you see that cost effectiveness. The others from Garissa Bonda to Mwingi, it's another around 400 kilometers also. So it's cost effective, saves cost time. I've been working with the magistrates within the Kitui, so they applaud the AJS because it saves time. Because that lengthy the trial detention is reduced. For example, if somebody has a date in September and they have consulted today, we organize have a PO on a near data. So out of prison. Again, our facility is small facility, so we have no resources. So when we go through the HAS, it helps us a lot. Because having a capacity of around 120 and having 200 plus really press us in terms of hospital, outbreak of diseases. So it has reduced the recidivism. I'm working with the community. The elders are here. The community involvement brings the restorative justice because it's something dealt in the community level. So they feel they own the process. I call the complainant when I get a case. I register them, send them to court, but I call the complainant first. I'm attending human rights office. I ask them, what is in it for you? This person is jailed. How will you benefit? He stole, for example, he stole 2 gold and he jailed for 2 years. How will you benefit? It's not benefit. But when there is a small compensation on what you stole, the justice serves the accused and the complainant. So I ask them, what is in it for you? This person is jailed. I look to them and I tell them, I don't want them to go out of prison because I will have no one to do. Again, I don't need too much number in that prison. It will pain me. Because a sick prison is a sick prison officers. I do interact with the community. I go to doctor, I go to teachers. So when I bring this from prison, in just a matter of 5 minutes, it's in the community. So we try to avoid contaminating the community by making sure the prison is safe. How prison be safe? Through making sure the populations, the right populations are there. We had about 64,000 as of today. I was calling somebody from my quarters. 64,000 as of yesterday. Yesterday by Sambili, it was 64,000. 64,000 against the capacity of 35,000. Half of the capacity are in prison. Times when they want to break blockade in Kami, killed around 137 inmates in hours. Because this officer in charge has nothing to do because of the congestion. They are so congested. Nawaambianga, we pack them. Kilala hivi kuna kuamuka. Kwa hiyo ward iko na watu 70 lakini iko above 150. So mnalala kama mko packed kama ngunia. Ukigeuka hivi, ukiamuka hauna hiyo space tena. So ni mpaka asubuhi. So this AJS is helping us. I'm employing to the Legal Resources Foundation and the funders. Have some more resources. We develop this thing. Now we are at the locational level. Chiefs and the elders are locational level. If we devolve it to the endman, it will help us. Reaching out to those people, areas of Mutomo, the areas go very remote. Those who have been there, the areas go very remote. Naona watu wengi wanatoka Jeff, the areas go very remote. So when it's devolved to the endman level, it will help work easier, make work easier. Again, the pretrial detentions. Unapata mtu amekaa mmoja amekaa more than 2 years. Ngoja. When we do the AJS, inapata anakuja kama leo, unapata next week kama wamereconcile ametoka. I sensitize them on weekly basis because we have new inmates every day. So on weekly basis, I call them. Wakamukuja, I sensitize them in a process, inaenda hivi. Again, we get challenges from the complainant. Tumepelekwa DCI more than 4 times. You are calling us from prison, you want to con us. So we need also to train those partners, the criminal justice system, police, DCI, judiciary are good. The others, unapata ni kama wanataka kusabotage the system. Police, 2 weeks ago, I called a complainant. Then I received a call from the DCI. You are tracking your number. Where are you from? I'm an officer from prison. So I sent him to court. Go to Mukomo Law Court, ask what is alternative justice system and who works for them in prison. So we had to make some arrangements so that this person gets to know there's something like this happening in the society. So again, to the funders we brought you, please make sure you program the police, mostly the police, because they are police, ODPP. I work with the ODPP, they are good. But the police, they are stumbling block to the system. Kinipeleka kwa DCI for tracking, surely. But sasa niwekea kesi. So they need to be trained on this system also. So the culture hapo kuna kazi. Ingine ni that community involvement. Wale wazee nafanya nao kazi, give reputable men of the society, selected from their societies. Ndio walisema tunataka huyu aende. So nikiwapigia simu wakienda to those societies, hapo tunaweza maneno mingi pia. So they are well received for society. Cost effectiveness, roofing, transportation to ports. Kama sisi tukienda Mukomo mahali tuko to ports around 17 kilometers. We have to take people to Kitui, to Mwingi, and to Mutitu. Mutitu is the fastest spot. About from Mutomo to Mutitu around 150 kilometers. So that's cost effectiveness. The AJS has assisted us. But again, I was looking at it. Kuna kitu kinaitwa crime sipua. I had started it. But now huwezi anza peke yako. Hakuna utatembea kwa society kueleza crime sipua na the reconciliation part from the ground before you reach the prison. So the court wakasema hawana funds. Sisi naye hatuna funds. So it stopped from there. The magistrate was so cooperative, but again he said, I have no funding. So you can consider that also. We synthesize the community on the importance of the alternative justice system. I'm not a lawyer, but zile cases napatanga pale naona, angalia naona this one haikupinga hata kufika hata kotini. Ikifika pale police who is trained on about alternative justice system and our advice wana reconcile from there. Kama unaona hiyo picha, we are in prison. That's Mutomo prison there. Trying reconcile these people. Lakini I feel mtu anatoka the farthest corner kutoka huko anakuja na gari moja inaendanga once. Kuja asubuhi ataingoja tena jioni. Una take 5 minutes unamaliza that process. Atangoja tena mpaka jioni hiyo gari. Alternatively tukipiki about 800 shillings on the kwake. Unapata pia cost effective. Unafanya kesi unangoja sana kwa sababu watu wanasema hatuna pesa ya kuja. Legal source condition is being good because it's facilitating the elders to move around those villages. Family strengthening, strengthening the families. Unapata kama ni hiyo reconciliation, piga hiyo simu, watu ya familia, the accused, the complainant, wanakuja pamoja. We advise them as a family. So wakirudi pale, ile uhasama hii mtu kama angefungwa na vile wamesameana, unapata kuna that cohesion in the villages. Because I've seen so many people, mtu amefungwa ananiambia afande, hii mtu alinifunga bure na nikitoka hapa nitakuja na kitu kingine kubwa kuliko hii. Kwa na moja Meru sometimes mtu anasema huyu mtu amenifunga 2 months bure, lakini nikitoka hapa nitakuja na kitu kubwa. Mtu iswande hapo kumaliza hata 2 months alikuja ameoa watu 6. The warring parties walikuwa wanasosania, so hiyo aliwahi kwa hiyo community yote. So through AJS it will prevent those cases from reoccurring under the recidivism. I talked about the conversion, the recidivism. Again, na kesi ililetwa na daktari hapa. Niko na 3 of those cases. Mtu alianzia Boston. Kana kesi ya Boston. Afungwa Boston. Toka Boston kuja prison sana graduate. Sasa prison. Huyo mtu alikuwa na wawili last time walikuwa na present ya upande na wakaachiliwa. Huyo mtu hata hakumaliza 4 hours office. Alipita kwa police station anataka kutoa ile kamba ya bendera. So akashikwa tena akarudi. Second ameachiliwa leo, second day akatela tena. What do you do to that person? The foundation ilipotelea wapi? Pale Boston. So those institutions pale iko hapa ya youth correctional center iko hapa Kamiti. Kumbiani kusema but the correctional part hiyo mtu bure. So akitoka pale anasema wacha niende ningraduate nikuje na kitu kubwa yenye sitafanya kazi nitakuwa na kazi. So anaenda kukuja na kitu. So the correctional AJS should also look at the children, wale watoto wenye I uploaded kuna ruling moja ilifanywa na Justice Tembo Mombasa ya mtoto walikuwa sexual offense mbuki mwaka. Nikiangalia mimi kama mzazi, I felt that this case imehit vitu mingi sana kwa sababu mtoto wamefungwa kwa kuimpregnate mtoto mwingine. So the justice said they defined each other. So utafunga nani utaacha nani? Funga moja just kwa yule mwingine itakuwa sawa. So kaachiliwa. Nao wale watoto wakifanya makosa pale kwa nini pale, they should not go the court way. It will start from the AJS. Jaji akiangalia anaona hii, rudini kule kwa wazee kwanza before we process the case. So that's family strengthiness. Ile nyingine ni voter free bargaining. Kama wameeleza vizuri sana hapo, but I've seen people wameenda into free bargaining, lakini prosecutor akienda kule anabadilisha. Hapa ile mtu anakubali na akienda kule anabadilisha, anasema ile kesi ilikuwa ni na napata ule mtu amefungwa. How it plays around hapo, anaongea na the complainant. Ule mtu akikubali, sasa amekubali, akirudi huko ni anafungwa.
atafungwa hata hakuna process kwa sababu si amekubali amefanya. So ndio msikiza kuangalia hapo pia, kwa sababu watu wengi fanya plea bargaining wanaogopanga sana. Kama nitakubali prosecutor aende anigeuzie. It has happened. So yangu nafikiri ni hayo.
Thank you very much. Let's clap for him. And thanks for now bringing us to speed in terms of the experience of the inmates and you as you interact with them and reminding us of the statistics, yeah? So out of 64,000, we can only have a capacity of 34,000, 35, and we have inmates 64,000. I've always been asking myself, do we build more prisons? Do we build more prisons? If we build more prisons, what will we be telling the world is that we are unable to deal with crime. So since the colonial times, we've only put up one prison, and it's because of the court that is in Loitoktok. Since colonial times, we only have one prison that has been put up in Loitoktok, and it's because of the court station that was established in Loitoktok. We've never had any increment in any other holding facilities, especially prisons built. Then number two, we've also highlighted that we spend like 3 billion, 2 billion per quarter. So see, I talked about 7, yeah? So 2 billion per quarter, that's about 8, yeah? And that is only on food. We've not talked about other expenses. There's a time I went to Kajiado, and I was told that inmates have not been brought, and the inmates were coming from Athi River. So you can see the distance between Athi River to Kajiado. Then nikaanza kucheka, nikajiuliza kama tuko hapa tu Nairobi, inmates wameshindwa kuletwa kutoka Athi River kuletwa kotini because hakuna mafuta ya basi. So they've not come, so the courts cannot proceed. Of course, the results are different. Watakuwa other dates. Now you can imagine people who are coming, watu ni wako mashambani huko. Hapa tu Nairobi hakuna mafuta ya kutoka Athi River to kotini. So we need to think about that. And thanks for bringing the issue of recidivism, and they need to have involvement of the community, sensitize the community on AJS, and decentralize AJS so that at least kila mtu aweze kupata access to AJS. And of course, the challenge of plea bargaining, which our sister will allude to. I have a question for Faith. You've talked about the mandate of NLAS is giving legal aid, but you've put emphasis on civil matters. I don't know why. The question is, and this you can relate to maandamano, why hasn't NLAS been giving people advice, even pre-charging during arrests? As we saw so many people being arrested, we've been seeing people going through arrests and wanachargewa, then they realize, oh, si ningekuwa hata nimeomba msamaha, ningekuwa nimeongelesha my complainant. Yeah.
Nilisema kwamba sana sana kesi ambazo zinakuja kwa ofisi zetu ni zile za civil in nature, lakini hiyo haimaanishi kwamba hatupati kesi ambazo ni za criminal. Ukiangalia sheria ambayo imetu create sisi kama National Legal Aid, inasema kwamba pia tunaweza shughulikia kesi ambazo ni za criminal, na hizo kesi zingine isipokuwa zile kesi ambazo zimeandikwa hatuwezi fanya, kama insolvency ama bankruptcy ama zile zinahusu kampuni na defamation. Sasa kwa challenge ambayo sisi tunapata maybe kwa hiyo kesi yenye Jemima amesema ya wale waandamanaji, mbona hatuendi kuwasaidia wanapoenda kotini? Ukiangalia sana sana sheria yetu inasema ule mtu ambaye anahitaji legal aid anaweza tu approach, either ukuje kwa ofisi ama kuna njia siku hizi tunaita case management. Tunaweza enda kwa mtandao na uapply mwenyewe kwamba unataka legal aid, na kutoka hapo tutajua. Hiyo ndio njia tunatumia. So application, ukiangalia hiyo vile utendakazi wetu tunahitaji mtu akuja atueleze, kwa sababu kwa kawaida hatuwezi jua kila mtu ambaye anahitaji legal aid unless utuambie kwamba hawezi jitafutia wakili ama hauna hiyo uwezo wa kupata wakili, ndio posa sasa ndio sisi tuweze kuja kukusaidia. So that is the challenge that we usually have, and they have to make an application for us now to know. However, for the people in prisons, the officer in charge akiona kwamba there is need for legal aid, kwa sheria ukiangalia sana sana Legal Aid Act, tuko na hiyo mandate ya in charge of prison kutueleza kwamba hapa tunahitaji usaidizi, either kufunzwa about the criminal justice system ama kuna hawa wafungwa ambao wanahitaji legal aid na tunaweza fanya. Na tumefanya kazi mingi sana prison, labda ni vile hazionekani kwa mitandao ama hatuja document, lakini tumekuwa kwa prison mingi sana tukifanya hiyo usaidizi. Sijui kama nimekujibu Jemaima.
Asante. Sarah, in terms of plea bargaining, what has been the role of the victims and the role of victim impact statements in the criminal justice system, and even as you deploy plea bargaining and diversion?
Sorry, Madam Jemima, before I answer that question, let me correct some misconception here. There's a difference between plea of guilty and plea bargain. Both end up in conviction. So with a plea of guilty, it is this person coming to say, makosa vile imesomwa ni ya ukweli. Plea bargain lazima tuandikiane. Na tunapoandikiana, unatoka ile makosa ya juu, ile makosa kubwa unakosa kuwa makosa ya chini. Bado kuna ile conviction. Wakati I've been to prison, these days I have an activity prison, and it was as a result of a forum like this. So that was last month. And we said, as actors, remember our clients are in custody. So when we sit here, yet the cases belong to accused person. Faith was in that forum. So one of the way forwards was we needed to go to prison through whatever forum. So for me, I joined a church. So I go to prison through church, and I am usually given a session to talk. And I talk. By the time I am done, you go back to where you started from. So when you are talking of prosecutor amebadilisha, one of the things that is happening is, yes, we have these directives, not directives, we have the policies, we have the sections, Article 159 and then Section 137, those rules in the CPC. The issue is, do all judicial officers understand what those provisions are? Do all prosecutors understand what these provisions are? Do all advocates understand what these provisions are? And by the time we sat in that workshop, we realized, yes, some understand, others don't understand. And so we are not speaking the same language. So this same language as Milimani, Kibera, and also Makadara, not the court users. This is one of the approaches. We get trained together. So prosecutors, prosecutors, judicial officers, we have judges, we have defense counsel. We also have police in the same training. In that workshop, we did not have the police. So the moment we have joint trainings, we will be speaking the same language. So by the time we go to the accused person, and we also come to the victim, of course we will be speaking the same language. So when you're asking about the role of the victim and the role of the victim impact, the Act, the plea bargain guidelines, together with the CPC, only talks of they're supposed to be informed. This being informed, the challenges that he's talking about, those are the challenges we encounter in court. Sometimes somebody does not even need to enter into a plea bargain. This is a question where somebody just needs to ask for an apology, and then kesi ishie hapo. But the complainant anasema, mimi nataka mpaka afungwe. Then we ask, how will you benefit out of all this case? All these. Conviction ni ile. Judges were telling us, conviction ni ile, whether iwe ya big offense or small offense. Record bado ni ile. So don't cling to those cases And you see, the people who are clinging to these cases, sometimes as a prosecutor, I am clinging to it because I have not really read the file. I have not really read those guidelines. It happens. So the moment we understand what these things are all about, and then that victim, you see, there's less sensitization in the society. We come here in these conferences, they are you call them the practitioners. You say these practitioners is just a representative of the society, but the areas that they are covering, wait until something happens, a practitioner anachukua side, mimi niko kwa upande. Sometimes they end up not being neutral in the whole case. So the moment somebody takes a side, and you see sometimes people behave in such a manner because of lack of knowledge. The victim in a plea bargain agreement is just supposed to be informed. And that is what I said, the problem, that is where the problem is. When you are informing this person, sometimes wanajifanya hawaelewi, ama sometimes wanajifanya wanaelewa. Mnapofika pale kotini, wanasema mimi hata sijawahi muona. I've been accused so many times. These are claiming, saying tumekula kesi yake. But I was telling her, for her to even come to the office, how did she know? I called the investigating officer. I gave them an appointment. They refused to honor because I met them in court. It was not documented anywhere. It was just by word of mouth. So I was waiting for them. They didn't come. I sent a letter to the investigating officer. So it is the investigating officer who now looks for them. For these people to come, there is somebody who has informed them. So for me, I held on to that. So by the time she's screaming here and causing all manner of drama, mine was, look at it. Who told her, or how did she know that this case is coming today? How did she even know our offices? It must have taken somebody's else effort for her to get that information. So we sat her down, and I was being accused, and I was also putting up a straight face. But you see, once you have been accused, sometimes you also have to lie low so that you hear what this person has to say. So I let now my division head to speak and speak and speak and speak. We documented it. Funnily enough, by the time this mama comes a second time, we thought she had understood and it was documented. She had signed that she was part of this meeting, you see, and even the minutes were there. By the time we are now reading the fact, she was there with us. By the time the probation officers are going to interview her, she said, hajawahi julishwa. You see, and this is somebody that we were meeting in our office. That was 3 times. And I said, let me take a back seat. I'm the bad one. So let somebody else now be in this meeting. So for me, I was just there, not talking, maybe just taking notes and akaruka futi kumi. So by the time we are now in court, we are here for mitigation. You see, she said she was not involved. And you see, she was not involved. There is a lot of dishonesty by the victims. So even if you were to involve the victim, you work daily with this victim, you explain, it will depend on the vested interest that this victim has. It will also depend on what is it that this victim wanted to achieve out of all this. We realized this mama who was now screaming wanted compensation. And this compensation was not forthcoming. As we told her, if you want compensation, yes, we can be included here. But is the accused person ready for that compensation? Accused says, yes, I am the victim themselves. Story changes. When these probation officers go to the ground, it changes. When these probation officers go to the ground to prepare that social inquiry report, the story changes. Sometimes we're even given at least a schedule of payment. So when this payment is not forthcoming, now the story changes, we don't want to live again. But as we are asking, haven't we informed you? Yes. What if we are not even using this plea again? We are just proceeding with this accused person pleads guilty. Do you have a say in it? You have no say. So this is one of the problems. Informing the victim are also coming up with their victim impact, saying, this is what we want. A list of so many demands, a list of things that were not even there in the first instance, the vested interests. So this has made AJS, if only we could create those awareness in the society. We do a lot of sensitization in prisons, like what he does. I do it at Nairobi Remand. Tomorrow I'll be at Nairobi Remand through the church. I do it. But the problem that you're facing right now, accused persons are ready. And when it comes to, there was a question here, when it comes to prosecutors changing the minds, we change not because we don't change our minds, we don't change our minds. What happens? Remember the thresholds test. Sometimes by the time we are entering into this plea again, we were waiting for some of the exhibits to be processed. So it was not fully the 100%. The evidence by that time, there are some part that was still missing. So by the time you get that full, unasema hapana, this evidence shows that whatever what we have right now shows that the offense that I'm about to enter into a plea bargain for, this is even less. So I'd rather revoke. We call it revoking that plea bargain so that we do the trial. We call the witnesses. Why do we do that? If you look at that guidelines, there are circumstances. Sometimes hata yule accused mwenyewe akikuja pale kotini anasema si mimi, you can't proceed. Si eti prosecutor ndiye amebadilisha maoni. Sometimes that accused person akisikia ile sentence, you remember we don't have a say when it comes to say, I can propose. He also proposes. The ultimate decision rests with, yes. So akiona wanapima, huyu amepewa ngapi, akiona inafika pale, mnasoma, anauliza huyu judge ama huyu hakimu anapeana ngapi? You see, that is the time when they now change their minds completely. So mimi as a prosecutor, of course, I'll be looking at what are the circumstances that permits me. If we change mind to revoke, I will quickly revoke so that tuonane kwa fields. Wacha nilete my witnesses so that the witnesses then wakiona kimemlemea anakuja sasa, they start begging. Mimi nataka plea bargain. So these things happen. See, prosecutor ndiye amebadilisha. There are circumstances. If you look at the guidelines, it gives the reasons and circumstances under which that plea bargain can be revoked by the prosecutor. And then as we talk of revocation, remember, judiciary also has a say when it comes to termination of this plea bargain. We have a situation where a judicial officer just writes, I hereby decline plea bargain. Unajua huku anakuja na kwambia ni prosecutor. Wewe huku kotini, but it is the judicial officer who has declined. So when the judicial officer has declined, accused is ready, prosecutor is ready. Judicial officer has declined. And you see, the guidelines talks of, in fact, the CPC talks of, you cannot appeal it anyway, it becomes final. We are stuck with those matters. If we had time, there's a very ugly case that all of us were confronted with. At the end of it all, the judge was being told in her face, you created this problem. Then she says, it is in the regulation. At the end of it all, we were able to come up with a resolution in that meeting. How do we move forward? It's a problem that is created by the statutes. We are just but implementers. So unless such a time when we can also have amendments, we cannot be the legislators to amend some of these
Kwa sasa ndo nasema pesa ngapi? 10,000. Unaweza pata ngapi? They just questions, then they agree. Unaweza pata 3,000, utanilipa aje? Monthly 1,000. Then taken to court, the court adopts it as a court document.
Okay, let's clap for him. Okay, so we've heard from NLAS about their role, how they work, and the involvement in the criminal justice system, but they need to sensitize and educate the community on their functions. Because we all know that we've had so many people who have been arrested, even during these issues of maandamano. They've been there in court, not in court, in the cells, but we've only seen LSK coming up to see how they can assist them. And even these issues of bail and bail terms and bond terms, nobody to even speak for them until now. There's an outcry outside, is when now we hear under various interventions that come in. Then number two, we've heard from DPP about plea bargaining, how it's working, diversion, how it's working, the challenges they've gone through. She's highlighted a few because of time, but mainly on the challenge kuanzia kwa prosecution wenyewe wanakuambia tunataka kumeet, pia hawezi kupata, wanaambia ayo alete mtu, we don't know whether the alimwambia ama kumwambia, but eventually when they sit mtu pia anakuja na kana, or expectations are high from both the complainant na accused. Accused anasema niki plead to guilty, huyu anasema mimi nataka unilipe, so inakuwa challenge. We've had the role of LRF. I know they work with the CUCs, but now I think when I was a prosecutor, there was the issue of having joint trainings. Because you cannot sit with the prosecutor na mfunza juu ya plea bargaining na magistrate ameachwa kando. Na una expect ataenda kwa pia before this magistrate na magistrate anakuwa anaelewa. One group wenye we assume they should know and they know everything are the magistrates and the judges. We assume that these people are the most educated. Nikienda tu kotini, they should know what is the current policy, how the policies, we always assume. So sometimes you get into confrontations with the magistrate. Like there's a time nilikuwa kotini nasema I need to speak on behalf of the victim, then the magistrate ananiambia you're speaking as but as a victim's lawyer. Kanambia, but there's no law telling you to kwanza kwa nagamba kwani sheria ili change, because for me I was like, who magistrate should be knowing I have a right to speak on behalf of the victim as a victim's lawyer. So sometimes we assume that they know everything. But generally, they need to have all the players, even the police, probation officers, because hao ndo wana interact na watu. Hao ndo wanatupatia reports. How can you train them on these policies? And have sessions, in fact, we are strong regional because you're bringing magistrate anakaa hapo na prosecutor wake, na chief inspector wake, mkubwa wa prison hapa, mkubwa wa probation. So they sit together in one table, they discuss their issues. Kama ni Isiolo, tulete hao watu wote, from the chief magistrate to the inspector, nani pamoja wakae hapo. So thanks Sarah for bringing that as an issue that we need to look at as one of the challenges that we have. And also for LRF, that sometimes, yes, we go the CUC way, but that's just a 1 hour session, 2 hour session. We need to really invest. Ndio tutoke kama enyewe tumesema tumefanya kitu cha maana. 2 days session, watu wakae tu tusemezane, tuangalie changamoto na tujifunze pia on the new policies. Thanks so much for highlighting what AJS is doing, the impact in the prisons. Looking at the numbers, enyewe unasema uko na 200 na watu wangia 120. Last year I had the opportunity to go to Lamu. Tukaenda kwa hiyo prison ya Lamu inaitwaje? Hindi. Yeah. I went to India and I'll never forget that picture. So, of course, I think even where I come from, niliona prison imejengwa na matope. But I went to Hindi prison. So, unfortunately, I didn't go to the men's side. We went to when you get to Hindi, the first one is the ladies' side. And then sasa kuna men's side. So ladies' side imejengwa na matope. They're just it's just one room imejengwa na matope. Can you picture that? I know my brothers from Nyeri and they've never seen anything imejengwa na matope, but at least some of us from Western we have seen. So imejengwa na matope, na of course haija bomwa vizuri because sisi tuko tunafunza as you are growing up how to kuboma. So kuboma unaboma na samadi ya ng'ombe. Of course you don't expect ng'ombe huko ya samadi ya ng'ombe. So imewekwa tu matope hivi. It has not been smoothened. Kuboma inamaanisha kuwa plastered. Okay? So it is one room. Inside that one room kuna inmates wenye wamefungwa wamama. So this is the ladies prison. So kuna inmates, yeah? Wamama wamefungwa, there are 3 or 4 of them. Then kuna the remandees inside that room. So kuna nyako kwa remand. And then kuna mothers accompanied with children inside that one room. The room is not this big. The room is 10 times. No, a tenth of this. Yeah, a tenth means from where these this banners it is. So this is the room. That's why these people are sitting. So I asked myself, watu wanakwanga huko Nairobi wakiongea huko kwa prison, kwa nini kwa political rallies na wenye wameka huko magereza house na DPP make statements na Chief Justice. Have they ever visited Hindi prison? That's what I asked myself. Have they ever visited Hindi prison? Now, you know we have various rules, ndio? One of them, inmates wasiweke pamoja wenye wamefungwa na wenye wako remand. Then we need to look at issues of children. We need to look at, hizo tukanaweza vitu zimeandikwa mahali. Then the question nikajiuliza kwa mind yangu, watu wamei visit Hindi prison. But now, where I come from, here in Kapsabet, there's a time when I was a prosecutor doing All for Justice. So we visit quite a number of prisons, holding facilities. So nilienda Kapsabet. Then nikaona hiyo prison imejengwa na matope na iko Kapsabet town. So I asked myself, hii ni Kapsabet town. And that time, Kapsabet, watu high court ilikuwa Eldoret. So mnapelekwa Eldoret for hearings za high court. But imejengwa na matope. So if you've never seen the state of the prisons, so I've given you just a tips, yeah? I think also Kakamega, Lena Kakamega, it's built by prison. The worst was in Kakamega was the children. Their children, because it's in Kakamega. The children one in Kakamega serves the whole of Western. Inaitwa? Shikusa. No, not Shikusa. The one that's just next to the prison. Here, watoto wasichana. Si wasichana, watoto. Okay, it's called Shikusa. So it serves the whole of Western. So you can imagine if you're coming where you came from, Busia. Yeah, so me I'm talking about Western. So mtoko amearestiwa Eldoret nini Busia analetwa Kakamega. But that was not the issue. The issue is now it's mix of boys and girls. And you know the Romeo and Juliet. Anytime you report about huyu amedefile huyu, the first thing is they take the boy anachajwa for defilement, and then they take the child and open a file for care and protection. So now we have both of them in one cell, holding facility. So the Romeos are on this side, yeah, the men during the day, yeah, wamekaa hapo wanacheza, veranda iko tu hapa hivi. So men are this side, the Juliets are on this side. So I was asking myself, so this Romeo is just looking at Juliet. And asking, oh my God, hey, how was it? Now, what wako hapo? Romeo is this side, Juliet. So I'm just telling you the realities that we have when we talk about alternatives to imprisonment and the need for us to engage and have these discussions. We're not going into the issue of numbers. We've said that several times, but now that's the reality. I usually take numbers. If you have anything to say, any question for any of these panelists, anything that is not clear, please put up your hand. Number 1, number 2, number 3, number 4. So we are taking the 4 of them, they respond, and then we break for lunch. Asanteni. Number 1, number 2, number 3, number 4.
Thank you.
So you can keep it short. If you're asking specifically somebody, specifically who you or general, it's okay.
Thank you, panelists. My question is to Madam Sarah. I would like to know what you think about whether there's sufficient trust between the former judicial system and the AJS practitioners, and what do you think should be done?
Yangu ni pendekezo, sio swali, kwa sababu mengi mumeyasema. Tunakuwa na shida kama vile wengine wamesema sana na polisi, na wakati mwingine hatuwalaumu kwa sababu polisi makosa ikikosa kufanyika inaonekana kama unga yao inamwagika. So wakati tunajaribu kusema ni kushirikiana na hawa tujaribu kuzuia, unakuta hawa kwao hiyo hawachukutilii maanane sana. Yaani unajua kuna mambo ya sheria lakini kuna ule ubinadamu. Na kweli anaona gumu kwa sababu amekipizana na mhalifu kwa muda, alafu mhalifu analetwa polisi, alafu nataka umalize kwa urahisi tu. But haangalii madhara ile itakuwa pale mbele wakati mtu atapelekwa jela pia itakuwaje. Kwa hivyo hapo tunakuwa na shida. Kama vile mmoja wao anasema ni vizuri polisi waletwe karibu sana. Kama prevention, tuwalete karibu sana kuonyesha umuhimu wa kumaliza badala kumaliza mizozo na njia ya kwa njia nyingine, kwa njia badala. Pia nikipendekeza pia ni vizuri hata wajitokeze wafadhili wengine, na nashukuru sana Legal Resources kwa sababu mmejaribu sana. Kama mko na pesa muongeze, na hata pia mtafute wengine wafadhili kwa training, na sana tutumie hata wale ambao wamepitia, wale wamekuwa jela na wameoja mateso ya jela. Watatusaidia sana kuongea kule mashinani kwa vijana, kuwaonyesha madhara watapata wakiingizwa pale jela. Pia tukitumia pia urafiki kwetu kama wazee, tunakuwa na urafiki wa karibu sana na askari wa prison kuliko polisi. Manake mimi najua kama vile nasikia madam wakisema ati alipata prison ya matope, hata mimi nashangaa sana. Hiyo ni kumaanisha hata mwenye kufanya hiyo jela hajui ile riski huwa na askari wa jela. Askari wa jela huwa amepelekewa criminal ambaye amezubua dunia mzima, alafu askari 10 ndio wanachunga yeye. So, unaona yule mtu criminal anaweza kufanya chochote. So tunakuwa na urafiki sana na hawa kwa sababu hawa hawataki usongamano wa wafungwa kule jela. So ikiwa tunataka kufanya training, tuwatumie sana hawa askari wa prison. Asanteni sana. Oh, sorry. Kuna watu wanaitwa advocate. Kusema ukweli, mawakili hawaja kubatua hii kitu. Wanaona kama tunawamwagia unga. Sijui hawa tutawafanya nini, hiyo swali nitakupa kweli nikuambie tutafanya nini mawakili waone sisi hatuwamalizii kazi. Tunapunguza uhalifu na tunapunguza nini mtihani. Sababu hawajakubali hii kitu. Sijui kama ni kwetu ama Kitui na mahali ingine hivyo. Mawakili mnashirikiana vizuri kama kesi kwa inaenda kwa wakili, alafu inatolewa inaletwa kwenu, anaona kama umemwaga unga.
Mawakili, so we need to address that. Sijui wako wapi. That's what tumeleta Morris Kimuli atuambia mawakili wake. Number 3. Thanks, Njogu. As you speak, unajua, one thing to know that this person is an African, and not only an African but also a Kenyan. Akipewa microphone na ilikuwa ina work tu vizuri. The first thing they do is to do what?
Hello? I had to be sure. Thanks. Two quick questions. Swali zangu ni mbili. And thanks so much, Sarah, for helping understand further in terms of the decision to charge. I've always wondered, in terms of the child, because we say they cannot enter into a contract, and plea bargaining agreement is a contract, then the parent or the guardian does it for them. What happens if the child says he does not want that? And referring to the Children's Act in terms of the best welfare and best interest of the child principle, and the child says, Mimi Yostaki, have a different opinion on what should be taken. But then secondly, swali yangu ya pili ni kuhusiana na something we have observed. In the last, I think, 3 months, I've personally sat in a number of coach users committee na pia kuongea na wazee, na kumekuwa na some level of lift and misunderstanding, I would say, more so when it comes to alternatives to dispute resolution and the mediation that is also led through the court annexed mediation, and on some of the cases zenye zinatupia wazee. And this is in respect to the participation and the role of the DPP. So you find a judicial officer ametuma kesi iende isuluhishwe badara, but then there is objection. And that I've realized is a pattern because of late, the last place I was in Turkana, Lodwar. But I've also gone to other courts, and that has been the saying. DPP says no, and more so when it comes to criminal matters. So I would probably want to know, is there some level of decision that has been put in terms of the engagement of the DPP when it comes to matters of alternatives, regardless of either under the platform of AJES or court annexed mediation or the rest? And how do we tackle that? Because on one side, we are hearing good news that alternatives are working. But on the other side, we are observing some level of objection or what needs to be done to reconcile this. But otherwise, thanks so much, and especially more. I must commend the DPP on the decision that was done yesterday. 2 years and we had a murder case, ule jamaa pale Nakuru, you know. Me and my kids were saying, tuliona kwa TV tu juzi, and it's now concluded. Sends a very positive image and communication to the world. Thank you.
Thank you very much. Let's clap for Njogu. He's really done a lot of work in the criminal justice issues. Number 4. We're number 4 ako wapi? Oh, sorry, it was you? Yeah, number 4. Thank you.
Yeah, thank you very much, the presenters, and thank you, LRF, for the good work that you're doing in terms of promoting alternative justice mechanisms. So there are various advantages that we talked about that we can see when we use them. For me, it's about collection of data and statistics. How can we link AJS to reduce congestion? So as we implement that program, or as we implement AJS, and we say, like, for example, in a particular area, AJS is working very well, then we should be able to see statistics to show, for example, a decrease in the number of prisoners, so that you can at least have an easy time. We can at least be able to show that there is a reduced cost of taking care of prisoners other than, food, the transportation. So I think as we move to implement, let us also collect data on where it's working. Is it actually reducing this congestion, reducing the costs for purposes of even advocacy for more resource allocation to this area?
Okay, thank you very much. I'm so happy to hear that, because it's one of the things that we need to look at. I heard him talk about 180, and the statistics I have was 50 something from the same LRF. So we need to see how do we synchronize statistics. I know I'll be coming to you now that we are having the SOJA for the 2024-2025. So we need to get correct data and case studies like, a case scenarios, because when you use a case, like I've told you about Hindi, I know all of us are now thinking about Hindi. Okay, you'll never forget, yeah? I've told you about Kapsabet, you'll never forget. You desire to go and see actually is it real, yeah? So when you have also proper case data, proper cases to showcase that this is an example of an issue that was dealt with, like Jogu is telling about a murder case 2 years and now it's been resolved. It gives at least people to understand how does this work. Also for plea bargaining, I know we've had challenges of getting the correct data on plea bargaining and diversion. And when you ask DPP, tell us number of cases you've diverted, hapo ndo kizungumkuti inaingia across the board. So data has been a challenge. We need to really see, do we put resources to actually, how do we put resources to get the data? Last was this, may resolve cases ngapi? Huku hivi tumeresolve 2 cases 5. Yet you go down, you find wako na 20 cases, 30 cases. Before I come to comments from them, we have our magistrate here. She has also a comment.
First of all, is just to thank the speakers. Thank you very much for the work that you continue to do around these spaces. I just have a few comments and mostly it's to weigh in or just to add on particularly what Madam Ongweno said as regards plea bargaining and what feedback you get from the inmates when they say, waliniruka. So in terms of the procedure, as we are handling this process in court, there's a questionnaire that the court takes the accused person through. It has 18 questions. All these questions are around his rights to a fair trial. One of the questions that we ask the accused person so that he understands as he's going into this agreement, these are still his rights. And one of the things that we confirm from the accused person in that process is that he understands that the court has the discretion to mete out a different sentence from what they have agreed or proposed in their plea bargain agreement, which they accept, and it is documented. So that even cushions everybody, that nobody should come back and say, "Ai, waliniruka," because the court will look at everything at the point of delivering a sentence and see what is the most appropriate sentence to offer at that point. On the other issue that I wanted to talk about is the voice of the victim in the plea bargaining process. We have also encountered that challenge. I'm just thankful that where I am currently, we also practice a bit of plea bargaining in Gishugu. And what we decided to do is to get a social inquiry where we have a serious matter before the agreement is drafted and entered into. That means my prosecutor has enough information about this accused person, about what the victim has to say about this entire process before they get into the agreement. And I think in that way, we're able to hear the voices of the victim. What does the IO want to say at that point before we get into the agreement? And so that really has worked as a safety net for everybody, just to ensure that even the victims participate in this process. So that one has worked for us. There was a question on whether there is trust on between the JOs, and that's for you, Madam, but I'm also waiting as a JO to hear your response. So that's no pressure on you. Last one is on withdrawals, and these are whispers, and maybe you can give me clarification. I understand that there is a directive in terms of any withdrawal to be done in the lower courts, that a senior prosecution counsel must appear on every withdrawal. I don't know if it's something that is now current with the office of the DPP, because what that will then do to us in the lower courts is just to give us another clog in the system, because you have one boss in an entire county, you have 4 or 5 courts mushrooming under that one boss. Will this person be available to come for every small one? Even there's something called Makabu, is a very fine drink from Kirinyaga. Will she come to withdraw these small ones? May be happy to hear from you on that. Thank you.
Okay, thank you. Let's clap for our Honorable Mnyendo, who has also had the experience on AJS and some of the recommendations on how we can work with other actors. So, Sarah, you have a few questions and then to respond to, and then we just wrap it up with a comment from each of panelists.
Let me first say that AJS is a very, very beautiful approach, and where you get
a success story, especially where families are involved. So instead of putting this person and they want to kuonekana, unaona? So at least you, instead of doing all that, trying to let them, tear themselves apart. So for me, we usually encourage AJS. Straight to the questions, the trust between AJS and other practitioners. I would say there's a lot of mistrust. And I had given the example where I am being accused by the victim's family. The IO was, yes, we had informed him, but there's a lot of mistrust. And there is no single time we will have that trust if we have not conducted the public awareness. So if we can also do those barazas, we go to those churches, we go to every place, the way we are all here. We are talking about the police, we are talking about the Defense Council, they are not here. So when we have those to small barazas, every opportunity you get, and you talk about it, because you never know. Sometimes we are talking like this, and the next moment, maybe I'm being called, your son has done this and that. And then the story recurs. Even from being a JS practitioner, you become a victim. So it's different. But it's usually very nice when it is. The shoes usually, it fits when it's on another person's. But there's a lot of mistrust. I can't lie about it. We have been accused so many times, including parties saying, I have given this money to so and so. It happens. But we have to, maybe it's due to lack of sensitization, because the judiciary is talking of AJS. Kuna a lot of mistrust. All the people we are talking of alternatives, not alternative 2. We are talking of Article 159. How wanasema yao ni AJS, so that when we are making those applications, they want to use AJS, but as we are talking of Article 159, yes. So we are very specific which one. So again, the judiciary and the ODPP have not really harmonized on the approaches. We all agree there is diversion. We all agree there is mediation. We all agree there is plea bargain. But the point of departure is yes. Next question about collaboration between members of the public and police. Let me just speak about the police briefly. I am not a police officer, but I wish they were here. Police usually tell us they are trained kushika mtu na kufanya investigation. Nothing else. So when we are talking of AJS, we are talking of plea bargain, we are talking of diversion. Mtu anakuambia unajua nilienda mpaka huko Nyanza kuleta huyu mtu, hata sikupewa pesa na mtu, ninaenda, unajua huyu ametusumbua mwaka mzima, tumempata. There you are talking about AJS. There you are talking about diversion. There you are talking about plea bargain. Can we have a paradigm shift? And how do we do it? If the police can also incorporate this during their trainings at Kiganjo. Na polisi pia watakwambia, mimi ni GSU, but sasa niko NPS. Mimi nilikuwa AP, sasa niko NPS. Mimi nilikuwa sijui wapi, nilikuwa NPS, sasa mimi ni wa DCI. So even if you sit with those police officers, you get a file, you ask. Sometimes you also ask their colleagues, kuna hii file imeletwa. It has been investigated, but we find there is a lot that is missing. So you also ask the colleagues, what are the GSU people trained to do? Are they trained to investigate? No. AP, are they trained to investigate? How, Linda? So that is where, if the training can be incorporated, whenever they have those trainings, whenever they are going to Kiganjo, right now there's a merger. So if the police themselves don't trust themselves, don't you think there is a problem happen? I deal with them on a day-to-day basis. Some tell you I was in general duty. Mengine nakwambia mimi nilikuwa court orderly. Mengine nakwambia mimi nilikuwa hii. So when you remove this person from a court orderly, umemrukisha DCI, umempatia file. So unajua kazi ya polisi ni kushika, kutengeneza file na kupeleka. You are telling this person about AJS. Have we also taken our time to ask the teething problems within the police, the trainers and the organizers and the sponsors, LRF? This is an action point for you. I said, let me just hold brief. I talked of from the experience that we encounter. We also have a problem. We see it. So sometimes we also have to humble ourselves, and then we take them slowly. Now, police ni mtu mgumu sana kudili na yeye, and then you see that hierarchy. You will deal with that police constable atakuelewa vizuri sana, but you see this police constable. So I fixed myself in their schedule, and that was after. The workshop itself. So we said, where can we start? So I took that challenge, and I went through my church and asked if they could give me time in prison. They usually come here to Nairobi remand. So I started with the plea bargain. Yes, I talked. I finished. The next time I went and talked about trial process, and I also invited my colleagues from the Court of Appeal and also somebody from the lower court. Trust me, we talked the whole day. They take you back to kila mtu ako na interest yake. But if we can involve the prisoners, the ones who have already left, and also the remandees, it makes a lot of impact. There was some guy that we had who had entered into a plea bargain, and as I was walking out of the prison, he came greeting me nicely. Zileza, Madam Bueno. You see, I was taken aback. Zileza, who is this who is calling me? And he's so happy. Then he introduces himself and tells me, well, I'm not the one who did that plea bargain. It was in the court where I was. And he was so happy. He was given 5 years. So, you know, he has become an ambassador. So if we can involve the remandees, the prisoners, either in prison or the ones who are out, so that they also share the experiences, this will have a very huge impact. But hiyo kusema crime sio poa, you see, when we were at the law school, we kept on asking, why do people keep committing crimes? We cannot eliminate crime, but we can reduce it. Elimination, But when it comes to reduction, there are some things that you tell them. No, this, of course, makosa itatendeka, ama this is the impact. One of the judges was reasoning that if we were to apply the longer sentences to deter, look at the sexual offenses. When you go to prison, the number of prisoners happen, those are people who have been brought under the sexual offenses. It is a fact. Senior, has it deterred them despite the longer sentences? It has not. So he said, no, let us embrace reforms, rehabilitation. Can this person show that he or she has reformed? When somebody comes to share their experiences, my experience is totally different from your experience. And when I was in prison up in Nairobi remand, because tukaongea. By the time we were leaving that place, now the pastor comes and tells me how some are so entrepreneurial behind those walls. So when you are fighting for this person atoke nje, yako na business. Making a lot of, because naambiwa wananunua mkate mapema. So I was asking, where did they get this money? So this, if it took Hapo prison, there are some who do not even want to get out because of the benefits. They have their businesses that they are operating Hapo. So it might help, but ile wanasema ongea, you just talk, but don't keep quiet. You talk. Maybe there is 1 or 2 people who will be changed by what you're saying. Child offenders and whether they have capacity, they don't have capacity. That is why we have to have a guardian. And in any case where a child is involved, somebody below the age of 18, whether in the children's court or in the lower court, they have to be represented by a counsel. And that is provided for under Article 50 and also in the Children's Act. So the advocate who is appointed by the court, they are usually registered under the pro bono scheme, and it is the judiciary that pays them. This advocate talks to the child, and you see kila mtu anasema si mimi. Of course, kama hata sio yeye. So this advocate who has been appointed by the court has to go that extra mile and looks for the guardian. And not every child akona guardian, and not every child has a responsible guardian. No. That is how they do it. The best. The best interest of the child. So the best interest of the child, these are contained in the Children's Act. So that is why every time there is a child offender, they are called the juveniles. They must have a legal representative at the state's expense. And it is the adults who will be making decisions on behalf of this child. So if the child says, I don't want to plea bargain, and if this adult feels that the circumstances warrant that plea bargain, then that legal representative of the guardian will execute on behalf of the child. The question is, by the time you come to court, you see the child will have to plead by himself. So if the child refuses, then it takes you back to where you started from. So you don't force. Cases belong to the person who is charged. The rift and misunderstanding when it comes to AJS, yes. So let me talk about the role of DPP in AJS. I'll go back to Article 157 of the Constitution, which gives the DPP, only the DPP, the mandate to make decisions to charge or not to charge. When you come to the plea bargain guidelines, as drafted under Section 137, the court, inasema the court have no role, except by the time the parties have entered into this plea bargain, ndio koti inajumuishwa, ndio hii. So when it comes to whether the courts have, the JOs have a right to refer these cases to AJS, I know this was a very thorny issue between ODPP and judiciary in Naivasha. So has it been resolved? Not yet. It has not been resolved because the judicial officers, after the judiciary has embraced this AJS, of course, they feel they have a right to direct cases. ODPP feels Article 157 gives them that mandate. So bado kuna kizungumkuti hapo. And how to tackle this rift? Bado. It has not been resolved. Let's go to, it's a good thing that it was Gishugu. Okay. You have a questionnaire because in Nairobi it was proposed that we have one singular document which Justice Joel Ngugi from the Court of Appeal agreed to draft and also to disseminate. Because he said when he was in the High Court, he used to have such a questionnaire. In Nairobi, we don't have a questionnaire. We only have the form for the High Court and a form for the lower court. So if you have a questionnaire, then maybe you can also share it with Madam Jemima in the Secretariat so that maybe she can also share it with other practitioners. But in Nairobi, we're waiting for Justice Ngugi to share a document with us. The voice of the victim. This, in Nairobi, what happens? We get this social inquiry report after, not before. So that's also a different scenario altogether because the moment we call it a pre-sentence. So it is usually prepared, but we comment on it once a plea of guilty has been entered or a plea bargain, those facts have been read. The accused person, now suppose the accused person says, no, I didn't do it. In fact, I am even walking out of this plea bargain. It means that even that social inquiry report will not have any impact in the whole process. So here the approach is a bit different. Withdrawals by DPP and direction by a senior prosecutor. Yes, what I know, there is a memo, but in every region and in every station, there is usually a senior prosecutor. So it was these senior prosecutors, you know, when you have an interest, well, let me not talk so much about it. Let me just say that we have the regional coordinators. Every region is a regional coordinator, and that is a very senior person. Every station pia ikona somebody senior. So it is just about, the memo does not say it can only be withdrawn by that senior person. It talks of everything must be documented. So that when you are going to withdraw this matter, I, Sarah, yes, I have a supervisor. I cannot just wake up and say, this is a matter which is fit for plea bargain. No, for me to be held accountable and for me to also make sure that there is somebody who is also supervising me, I have to prepare a brief through my supervisor so she looks at it, and if she agrees or does not agree, so that there is accountability. It's all about accountability. But kitambo people used to wake up, unasema hii kuna plea bargain, sawa, you just dropped. So I don't think the memo just talks of or that directive is strictly a senior officer. It's about accountability. Because when it comes to data, cases that were withdrawn, you can't even get. When it comes to explanation, because mtu takwambia, there was an incident in Kajiado just recently. Somebody is not in this court and they have already talked. It was a terror-related matter. Leaves her colleague and tells the colleague, withdraw this matter. There was no documentation, there was no brief. By the time a complaint is raised, the one who had withdrawn this matter says, I was told. In fact, I just went to that court to hold brief for so and so. And then the one whose court, the regular person, said, I didn't tell her. So it is my word against yours. So it does not really talk of, you cannot withdraw. No, it's all about the paperwork behind the scenes, so that through that paperwork, you can have an approval through the supervisor. Yeah.
Okay, let's clap for Sarah. Answered that very well, and the importance of accountability, but mainly the role of DPP. So it's not that there's a directive that don't withdraw. It's just the directive that at least let's have accountability. And sometimes some of these things happen, then you realize, oh my God, we've been having to make one panya roots mingi. We need to seal. So it's all about accountability and following the steps. I do appreciate. There's a matter in Kajiado, and this is all about some things that we do. Tunafanya tu kijuju. So this driver alikuwa anatuma parcel from Loitoktok to Nairobi. So in that parcel kumbe ilikuwa ni bangi. So the conductor tumezoea tu andika jina, andika namba ya simu. Ukifika Nairobi, call. So the conductors and the driver wamepewa luggage. Of course, wakifika njiani ikakuwa intercepted. Wakauliza umebeba nini? Wakasema asi tulipewa hii na mtu fulani. When they call that number, of course, it's off. You're calling the person is supposed to pick, the number is off. So at the end of the day, imagine the driver and the conductor are the ones who are held accountable. Meka prison for remand for 2 years before any interceptions. They could not even afford bail. Bail imepunguza, they can't afford. Of course, police wanaambia sasa wakuja wa testify, they know how to testify. Na wakakaa ndani for 2 years. So some of these things tunaona kama tu it's ni kawaida. But now tuna realize that we need to actually do more than just the kawaida things. Just half a minute for each one of us, your parting shots. Let's clap for the panelists once again.
Thank you so much. I think AJS is a very good initiative and it will assist us in dealing with matters. So unless we are now tapping in the criminal to be visible, it's not that we are not doing, but we will be visible. We are having more counsels who are coming on board, mostly to deal with criminal matters, and that will now appear in court and assist in these matters. Thank you.
Okay, our clients, we are here because of our clients who are in prison and some who are out, especially the ones who are in prison. So can we go to those prisons and talk and get some moment and talk to our clients? Because when we sit here, we are not really helping them. So the information we get here, if we can also go to prison and talk to them, it will have a very huge impact in terms of decongesting and also ile kupeleka inaitwa nini mashinani, taking services closer to the people. Yeah.
Sasa kwetu sisi tunasema justice delayed is justice denied. So let's embrace AJS. Let's give the people the power to make choices of what justice means for them, and I believe we'll have a cohesive society going forward. Thank you.
Kwetu kama prison tuko na open door policy. Karibuni. On behalf of my commissioner general, you will not take any offense. So ile ingine ni kwa committee. Pale kwa ile committee hakuna any representative ya prison. So daktari, for the consumption of these things, it has to start from the end office. So kama my boss hajaijua hii kitu, naenda kwake namweleza niko na watu nataka kufanya NGOs hapa. Hiyo ni nini? Unaleta ma NGOs hapo bila my authority, so you need to train them on the AJS, the outside charges and the end office. Thank you.
Okay, thank you. Let's clap for the panelists once again. You can stand up for a group photo. Yeah, just a minute, a second, please, for the photo. Hata mimi naingia hapo.
Vice Chair. Vice Chair.
Let's continue the conversation during lunch. I hope we can start exactly at 2, have 1.5 hours and finish by 3:30. So our lunch is just up across the pool. Enjoy your lunch. I've given each one of you a meal card. Please enda nayo ndo peane. Hapa ni Nairobi. Huwa wa entertain mtu mwenye gate crashers. Yani budget ya kwanga limited. So lazima uende na hiyo meal card. Asanteni sana.
Hold on. Sasa unajua watu wameenda lunch. So alisemaje? So tunatoa ama tunafaa umuulize kama ni pia nasema pia wanasema wanalia, wanasema wako na job. Na hii mixer pia inafaa iende Serena. Bado ile ni ya baraza. Tu piga alafu niambie.
We have English and Kiswahili. So if you can speak English, then speak very well. If you can speak Swahili, usikonde. Speak Swahili. They are both national languages. Na mtu asitu stress. Aya.
Thank you very much, Jemima. My name is Julie Wayoma Madheka. I work with the Kenya section of the International Commission of Jurists, ICJ Kenya. I would be remiss if I didn't acknowledge the presence of our executive director. He's hidden at the back, Mr. Eric Mukoya. Yes, Eric is here with us, and I'm sure he has worked with a lot of you. So I'll start with what ICJ Kenya is. ICJ Kenya is a membership organization with members from the bar, the bench, so wakili, judges and judicial officers, academia, students, and basically anyone with a legal background can join and become a member of ICJ Kenya. We are grounded on the fact that we work on the issues of human rights, rule of law, democracy, and governance. Our work on this particular issue has actually been there since our existence. We currently coordinate 6 paralegal centers across the country. We have paralegals in Kitui, Meru, Trans Nzoia, Laikipia, Meru, if I've not said it already, and Kwale. So we have 6 centers with paralegals. We not only work on the ground with paralegals, but we also are members of the National Council on Administration of Justice. That's the NCAJ that brings together all actors in the justice chain to work to But also, because sometimes we're not there when someone is arrested, we have been intervening at the court process itself. So we either offer legal advice to people who have been arrested and are being charged with petty offenses, minor offenses, and then now we follow through on their matters. What we have seen is the over-reliance and overuse of the criminal justice system, which is a great concern. We opine that if we actually had diversion happening at various fora, then the numbers would decrease. For example, if you actually had someone who has committed a petty offense being given an instant fine, then this person wouldn't interact necessarily with the whole system. They pay their fine, they move. But let's also look at another side. If you had also the prosecutors applying the diversion policy, then a few people would actually be removed from the system. We have heard elaborately about the role of the diversion policy and how the prosecutors are using it. We believe that if we actually had diversion, particularly for petty offenses, then we would have a decreased number of people within the pretrial detention. Practical examples that I can give is we have overly represented a lady called Ruth. Ruth is a hawker in Nairobi. She ends up getting arrested almost every other week because of similar offenses. She's a hawker, conjure round her up, they put her in detention. We intervene, sometimes it's frivolous charges, sometimes it's actually quite elaborate the frivolous charges in terms of the intensity and what they could actually portend if she was sentenced. So we have been intervening in her matter. But what we often tell the magistrates and also the prosecutor and the others who are in that chain is, look at the ripple effect that this is causing on the criminal justice system. This is just one of the very many people who come before you, who are often always within the system. How do we look at these particular offenses as a conduit for corruption, but also as a conduit for overcongestion of prisons? Another thing that we have been doing at ICJ Kenya that is important is training paralegals in regards to how they can be the mediator or the legal representative for the various people who are arrested. So for example, at ICJ, we run a program where we are training paralegals on gender-based violence because we have noted from our statistics that there is an increase and an upsurge in gender-based violence post the COVID-19 pandemic, but also in light of other data that we are getting, even in regards to the rise of femicide. So we have been training our paralegals around how to engage on the issue of gender-based violence. What we have seen with some of the reports is that this has led to a decrease in the number of offenses that first are coming to the courts because some of them are not as grave. And I want to be very categorical that some sexual offenses, gender-based violence issues should go to court, but the ones that we're intervening on are the ones that are a bit minor. For example, assault, ergo a slap, or just domestic altercation, which could be resolved outside of court without necessarily having to endure the whole criminal justice process. So we have been working around that. Other issues that we have seen is the issue of how do we involve the paralegals within the system. So we have been facilitating our paralegals to be part of the CUC, to be able to assist the court understand the climate and the complexities of the environment with which they serve. We have seen this is quite important because if people understand the complexities of the area, then they can actually rejig their systems to appreciate what's happening in the ground. So if a place has high sexual and gender-based violence, can the court, because of its chairpersonship at the CUC, engage in conversation around that and ensure that people appreciate how this is a dangerous crime and how this should stop at some level? So I'll speak about the fact that for us as ICJ, what we have looked at in terms of AJS, and because you're a member of the committee, what is important for us as AJS is that first, the recognition of the fact that AJS works. I think by the fact that we are sitting here, it means AJS works. By the fact that we acknowledge that not all cases come to court, it means that someone somewhere is doing the right thing. So AJS is working in the community. For us, what we want to do is strengthen the relationship between community justice actors and the traditional mainstream justice actors. Allow me to use it like that because not every alternative justice actor is actually a traditional actor. We have seen the emergence of young people who are actually doing AJS. People who are working with touters, people who are working with the street hawkers. They're not necessarily old, but they're doing AJS. So allow me to say community justice actors, AJS practitioners, and then the traditional court system. What we also want to do is streamline the conversation around human rights. There are certain practices, yes, that are happening that are wrong, and some community justice actors are not aware. So we also want to cascade the human rights discourse down to everyone so that kila mtu ajue mahali sheria inafika, mahali sasa tradition ya amefanya is wrong. So that is another thing that we want to do and we are hoping to do. But I think importantly, when you talk about the experiences per se of alternatives to prosecution, I think the major issue is diversion from the criminal justice system. Also, looking at the end goal. So once a person is in the system, how then do we trigger the judiciary to respond in a certain way? So looking at streamlining and also strengthening the conversation around the new sentencing policy guidelines, which actually speak to the fact that some offenses should not be custodial offenses. Some offenses should actually have non-custodial sentences. So how do we emphasize the issue of judicial officers can actually give fines, can actually give warnings, can actually give cautions, can release someone? And we saw that, I think, 2 days ago in a certain court where someone did agree that indeed alikuwa amechoma tire kwa hii protest na akaachiliwa. So it's also possible for us to look at how can we decongest the prisons, how can we decongest the criminal justice system through various mechanisms, ergo through diversion with the ODPP, but also as a court, how do you ensure that people who do not belong in the criminal justice system do not end up there? Strategically, I think it's important for us to also look at the penal code generally. I think some of the penal provisions that are being used against people should be considered for revision. I do not believe in this day and time we should still be having colonial laws such as nuisance, idle and disorderly, loitering, because you all have freedom of movement and liberty. So we find that some of these things that actually bring people and end up getting them into the system ideally should not be there. So we're also looking at the whole general process of criminal justice reform by removing some of these laws, because we do believe that even though diversion and looking at ways, referral pathways out of the criminal justice system exist, unfortunately, if the law still exists that criminalizes these people, then we will have a challenge in regards to the use or misuse by certain officers for these particular offenses. So allow me to stop there. Those are my perspectives in terms of what we have been doing in regards to the criminal justice system and alternatives, but also to say that there is work. I think more often than not, when we speak, we don't give the hope. There is a lot of work happening behind the scenes. There's the review of the sentencing policy guidelines that has taken place. The Chief Justice launched these guidelines in 2023, and I know there's a big rollout happening. And even some of the conversations is, how do we ensure people do not end up within the criminal justice system, particularly before the courts? Another thing that is really big and has been more or less pushed by ICJ and LRF is the whole conversation around the guidelines on pretrial detention and the guidelines on petty offenses. All these documents that I have cited are available freely at the NCAJ website. So I see we have none from NCAJ, but I think I can make an attempt. I think it's www.ncaj.go.ke. All these guidelines exist. And then now if you use those guidelines with the AJS policy framework, I think we can find various ways in which we can ensure that people who are vulnerable, poor, and ought not to be in the system can be diverted out of the system. So I just wanted to say that that work is happening, but also to say that Kenya is a showcase for other countries in Africa. The work that you're doing on AJS has been modeled by so many people across Africa. And there's a lot of question and interest around how we can replicate this collaboration of community justice actors with the mainstream system. So endeleeni kufanya vile mnaendelea na tuendelee kukaskedi mission ya AJS kwa kila mtu, because we are on the right track. And I do believe that using AJS, using the policies that we have, we can end up making our system much, much better. Thank you.
Thank you. Let's clap for Julie. She's wearing 3 hats as she speaks. That's why she's taken quite some, to take us through a lot as a NCAJS member, committee member, as a committee member for the National Criminal Justice Reforms Task Force, or a committee under NCAJ, and also as an advocate for alternatives to imprisonment and to prosecution. Let's clap for her once again. Thank you for highlighting various issues, including strengthening all actors so that we can mainstream what is happening with both the formal, the traditional justice actors and other actors, as you've highlighted, to streamline issues of human rights discourse, application of diversion, and the reforms that are going, especially on the penal code and the issue of application of the reviewed sentencing guidelines. Thank you so much. Yes, let's hear from Odaya. Odaya has done so well in dealing with decongestion, and we have just the next 2 will speak. I don't know if Honorable Munyando will also give us example of Odaya or where she is now, but karibu sana.
Thank you, Madam Jemima. Good afternoon. My name is Stephen Githaiga Mukiri. I come from Odaya, and we practice court-annexed AJS. Here, I would like to share my experiences, and especially on the alternatives. And I would say that alternatives are actually ways that we are saying alternatives to court trial processes, and actually embracing the multi-door access to justice. And we say this is through AJS, because AJS has different models, and in all these, we are opening several doors to access justice and give justice, or actually make everybody to access justice. So therefore, I would be very proud to say that AJS was started in Odaya Law Court in the year 2012, 2013. And we are the pioneer court that started AJS in this Republic of Kenya. By that time, we had a judge by the name Florence Macharia, and this was started after we realized that there are cases that are actually petty and involve very close relatives. And when they come to court, you find that it becomes difficult because they still have a life after the court judgments and everything. And we really needed even to actually address the backlog of cases that we had that time. So we started, and that was very good. We were supported by the judiciary, and we have moved on since then. And I'm proud and happy to say now, I'm happy today that I was one of those who are involved in the initial AJS processes, and now it has spread its wings all over the country. So it's my pleasure to actually say that. Before I go on, it's good to say that today I have my chairman of Othaya AJS practitioners, Mr. Wachira. Therefore, I said I'm Stephen Githaiga Mukiri. I'm the secretary to Othaya AJS practitioners. But I would like to acknowledge my chairman of the AJS practitioners, Mr. Richard Wachira there. He has just delegated to me, and it's my pleasure, and I feel honored. So as I continue, I would like to say that as AJS practitioners, we say that justice for all will be achieved, or is achieved very easily through AJS. AJS does not have discrimination. It is justice for all because this is a very cheap process that everybody can be able to go through. Even if you don't have enough money, even if you are not able to engage an advocate, you are able to access your justice in your own way through AJS. Court Annexed is actually a model whereby cases are referred to the chairman of the AJS by the judge, or actually the magistrate. And now, when those cases are referred to us, we usually engage the probation officer who acts as the secretary and the paralegal officer to the committee. Then the administration, the chief, is always the chairman of that particular AJS sitting, and the chief coordinates the process, whereby other elders, other respected elders who are elected and selected from the community sit down and now deliberate the issues. So when this order is given to the chairman, it is usually brought by the probation officer, a sitting is convened, and then the complainant and the accused attend with their witnesses. And the first thing we do is that we make sure that the process is voluntary. So we ask them whether they freely agree to it, they freely agree to undergo the process, and when they agree and it is very voluntary, we just start the process and we start hearing the cases. These cases are usually cases that are involving very close relatives, very close family members, neighbors, and people who live together. We usually take criminal and even civil cases, and I would say that I'm happy that most of the cases that go AJS in our offices, in our premises, in our committees are usually very successful. These cases bring about restoration. These cases, the members participate themselves, so they give them a chance to participate in acquiring justice for themselves. People are free to discuss using any language, including their vernacular language, so that you can express yourself freely and in a very, very friendly way. All the court bureaucracies are removed, and therefore we actually let them participate. And as we continue deliberating, they feel that they have participated to achieve their own justice. At the end, most of the cases are very successful and they agree. It is very encouraging to say that most of the cases, the petitioners, those who have the petitioners or actually the complainants actually forgive the accused persons. And when they agree, the restoration is achieved, and at some cases they might agree on some compensation, and usually the accused actually pays the compensation very easily, and after that we just make a draft of the findings and what we have agreed on, and the probation officer will draft all the findings and resolutions, and they will be taken back to the court for adoption, and then they are enforced. So in Othaya, being the first station where AJS started, and having had started AJS, we really feel that AJS is a very, very good process that actually restores harmony, restores peaceful coexistence, and has assisted everyone to access justice. It has also been a source of empowerment. People are empowered and they are able to uphold women's rights, children's rights, and most of our elders now have been well trained. And at this juncture, I would like to say that we are very happy of organizations like FIDA Kenya and Draconia and other stakeholders who have been assisting in training our elders so that we are able to make decisions that are in line with the Constitution. Of course, we know our boundaries. We know what cases we may not be able to handle, or we may not even try to handle, like the SGBV cases and other cases. So we are very, very clear on the boundaries on the cases that we really need to handle and tackle. So therefore, we are saying that being a cheap process, being a fair process, being a process that brings cohesion and restoration, promoting unity in families, this is an area that we would beg the judiciary and actually our community to promote. As the Constitution tells us, we really need to promote AJS, we really need to grow it and protect it. It actually gives respect back to our cultures, because even before the judiciary came and everything and the judicial systems came, our forefathers had their ways of resolving their disputes. And when we do this, we are taking back our people to their culture and actually even empowering them more to observe all the human rights. So therefore, I would say this is a situation whereby each party receives a win-win situation. It's not like what happens in court when a verdict is made, imprisonment is done, and therefore we are proud of that. Of course, other speakers have highlighted the benefits, like what Mildred Darum said, and also Corporal Gitonga, just as we have talked about the benefits of AJS, so I may not belabor so much, but I would only beg that more funding should be put to assist and grow AJS, and even to facilitate those elders who are helping our community deliver on their mandates, actually bring peace and harmony in our villages, and let everybody access or allow or facilitate our people to access justice in their own way. When a case is done by AJS, we say one makes his or her own verdict, and therefore that person is bound to respect that and keep that, and even help to deter any recurrence of such issues. I would again go and continue and say that we have experiences on imprisonment, and what we find is that through the court processes and the judicial process, when a case is done in court and a person accused is found guilty and convicted, it becomes a very big challenge. It creates a beef in the community, and it creates a lot of grudge in families. And this one is a major challenge. Therefore, it also makes the same crime or other grievous crimes to happen later. Because this grudge will continue, this person will be taken to prison, and after getting out of prison, the same person is going back to the same community. The same person is going back to the same parents. Therefore, what will happen is that there will be some kind of revenge, and a more serious crime is about to happen on some people who may not have been rehabilitated, who may have held very serious grudge in prison. The after effects of this is disunity and lack of peaceful coexistence. And it has also been noted that during court cases, there are some challenges that happen. When witnesses note that the critical evidence required to convict a person in court is bound to imprison the accused, they usually don't cooperate. They usually decline to give the critical evidence that the court requires to make a judgment. And therefore, you find that it becomes very expensive for the state, it becomes very expensive for the community, and justice is not, sometimes it's not achieved for all. Therefore, we would like and we would beg that we continue supporting AJS and every actor to help. It is also important to say that when justice is achieved by all and it's felt to have been achieved, this is the greatest success. And therefore, that this is the greatest success for AJS. I'm happy to say that I'm seated next to my mentor, who has been a judge in Othaya Law Court, and we have worked for very many years. I would have so many things to say, but now that we are here, and from the local community, I've commented on issues that and the experiences that we have had, I would think that mine would be only a request. And the request is that everybody who is here, let us champion and campaign in all ways to facilitate AJS in whatever models, in whatever methodologies, so that AJS will actually bring all the benefits that we are talking about. It will decongest the prisons. It will reduce the backlog of cases in the courts, and it will also remove very many expenses in our budgets, in our coffers, in our exchequer, and even now promote economic growth in the community, because people will work harmoniously and they will be able to actually be more productive.
Okay, thank you very much. Let's clap for him. Secretary from Othaya, and you've really highlighted how the court annex AJS is working and how it was formed. I hope during a break you'll be able to have a discussion with Othaya, because they really did quite a lot in terms of minimizing the criminal conducts and other acts like Mungiki in Othaya through AJS, and to really emphasize on the benefits of AJS and how it becomes binding, because parties make their own, they write their own judgment, they make their own decision, and the attributes that, it's a discussion, the language that people can use. But I'm so shocked here, people are using very nice English. I need to go back and become an AJS practitioner. Yeah, and the fact that it restores harmony, because I told you 95% of cases are actually, you know the person that you are suing, or it's either a neighbor, a brother, a sister, family, a relative just next to you. The time the magistrate was for. A husband to be buried across two parcels of land, yeah? Nusu ikuwe isaidia huku, nusu ikuwe. I don't know how nani alichukua kichwa, nani alichukua mguu. And we cannot even just agree how somebody can be buried. So the magistrate was order that you lie the coffin across. Nusu ikuwe isaidia huku, nusu ikuwe isaidia huku. Quite interesting. So yeah, let's hear from Honorable Mnyendo.
Colleagues, good afternoon. Good afternoon again. I'm very, very happy to be with you this afternoon. As you have heard, my name is Monica Munyendo. I am a principal magistrate. I currently serve at Gishugu Law Court since last September. Since 2018 to 2024, I was serving at Othaya Law Court. I served alongside this great gentleman, Mr. Githai Geiger here was my area chief, and Mr. Washira was our chairperson for AJS program. Mr. Githaiga has done 90% of the work. I will not even repeat one thing that I said so that we do not sound boring this afternoon. Tuko pamoja. I want to shift gears and just talk about what is the experience of a judicial officer in court. Sisi wenye tunakaa kotini, tunasikia aje ama kupatana aje na AJS wakati tuko kotini. And that's what I want to focus on this afternoon. The very obvious one, which we preach all the time, is to say, ukitumia AJS for a very long time, you will clear backlog, you will have less cases coming to court, you will have a faster resolution of cases. I am here to say, yes, it works. Vile mmesikia, Othaya has practiced AJS for a very long time, over 10 years, over a decade. Really, I did a lot of work with them until I told them, I've plateaued. I don't know what else I can do for you people. I have done everything. And why I felt that I have plateaued is because I saw it all. Waswahili wanasema yule ambaye anasifu mvua imemnyeshea. Mimi ilininyeshea AJS ya Othaya. And they did a lot of work in criminal litigation. At some point, both courts, we had 2 courts, but we had only 40 pending matters, 40 cases, kotini. 40 cases, I think mtu wa Makadara atakwambia hiyo ni cost list ya siku moja. Hiyo ni kazi ya magistrate moja siku moja. Na hiyo ni kazi ya koti yote. At some point, we had 7 remandees. In the 6 years I served in Nyeri, you can go to Nyeri and ask. We were always ranked as the best court in having the fewest number of remandees in court. And it is because, my brothers and sisters, AJS works. Tuko pamoja hadi hapo. In the time that I served, our court was ranked as the best court in case clearance rate for criminal cases because of the work of AJS. Kesi kikuja kotini, all these petty small cases, wacha ziende kwa wazee. Mtuachie sexual offenses, serious robberies, serious cases that would need a judicial mind to work through and deliver justice to the people. And I really, really appreciate the DPP is here, and I want to thank and really, mine is just to give back and say, I have gotten very good support from the DPP, all the prosecutors we've worked with. There's nobody who will be sluggish. Hata mtu akisema, does the court trust AJS petitions? I'm like, kuna mali watu wanasikia koti haiamini wazee. We trust, and I think they know we put them at a pedestal because we have enjoyed. My work was so easy. I don't even know how to deal with a cost list of 7 matters. I don't know. I have 40 pending, and 40 we are splitting between 2. So if courts that have started, the Baringos, Isiolo has also been there for some time, you would imagine what stories will we be talking about in the next 10 years, in the next decade. And I used to tell Professor Ngugi, this is what a model court should be. Watu wanaingia wakitoka. 2 months, even you've done a whole robbery with violence and concluded and delivered a judgment because you have very little on your cost list. So that is the obvious. Hiyo nimesema ni matangazo yenye kila mtu anajua. But what Dr. Okoth said this morning, that we have talked so much about AJS, that we should all embrace, we should all refer matters, but we should also innovate. We should create. We should think outside the box and ask ourselves, at what other point can we refer matters to AJS? And I want to talk about that. And as I go into that, I sit in court and sometimes I look at myself and sympathize at what justice we give the people of Kenya. Kwa vile kama koti, the men in this room will agree, if someone slaps if your brother slaps your wife, hapa mmeka unaambiwa sahi nyumbani mtu ameka bibi yako coffee. I don't think it will be interesting. Okay? This charge will come to court as an assault case, simple assault. Sindio, if I hear this case and determine it, I will likely put someone in prison if he has a bad record. I may find this person, and if it was the first time he did this mistake, I may put him on probation, isn't it? Lakini cha ajabu ni kwamba I have not dealt with the justice need of these people. at all as the court. Hata nimemaliza, in 2 months they come back. Now it is grievous harm because now they slashed her hand. It has now escalated, isn't it? And if I sit in court and I ask myself, what is it that we are doing wrong? And it is because how the criminal justice system is designed, we are not meeting as the court the justice needs of the people of Kenya, and that is an awakening to the judiciary. That case that I'm talking about a brother slapping Bibi and ndugu yake. And it was very funny because I sent those people to AJS. And then I realized we are doing the wrong thing. I sent that family because they are relatives to AJS, and I saw the outcome. Do you know what the outcome told me? What these elders decided? The accused person is supposed to build his own latrine in the homestead. And he's given 30 days to build the latrine. They're happy to withdraw the case. The report will tell me they hugged and have apologized and they're now happy. Then I asked myself, is there a day that as a court I will tell someone, go and build a latrine? Because nimemaliza kesi ya mimi niko kazi, si ndio? Kumbe, this young man who slapped his brother's wife is because he goes to his brother's toilet. Alafu, you know those people who use latrines, it's a calculated act. Unajua kama hujui kupiga calculation huko kwa pit latrine, that's why you bring problems. Yeah. And someone was bringing problems every morning on someone else's latrine. And so when the elders sat down, they realized where the problem is, which the court would never see in a million years, and resolve that dispute. And everybody was happy because ule hata alienda kachimba choo yake. Na hiyo choo ilichimbwa in 30 days, and that is the point we withdrew because choo imejengwa. Hiyo shida tumetatua ama tujatatua. Zamani practitioners, you are doing an excellent job. Okay? And keep doing that. That is the question Dr. asked. And I'm going to the second question that he asked, and I said, okay, so we've been asked to innovate. There is a case that I had in central Kenya. Ikifika wakati everything is ripening in the farm, then you will have offenses of stealing farm produce. Every day, 10, 12 people, every day. And they've stolen things of 300 shillings, 200, and you will deal with that every day. And they will go and they will keep coming back. I have Wanjohi. He came with his macadamia of 300 shillings. I heard he pleaded because he always pleads anyway. He pleaded to the judge, tukaenda tukaitisha probation, pre-sentence report. It came. Very bad report. This person has over 6, 7 previous records. Mbaya kabisa, aliiba ngwashe, aliiba nduma, macadamia ikiiva, you know, ula anachagua. Interestingly, he targets one complainant. Okay? Then I sat down and asked myself, this man has served time. How much time can you give someone who has stolen macadamia of 300 shillings? You won't even give 30 days. Even by the time you sentence, he has done the time. Anyway, you just tell him, go home. Isn't it? Amefanya CSO. Amefieka kwa chief 30 days. Alirudi kuiba kwa shamba. Then I realized and I asked him, what is wrong? It seems something is very wrong because of that question that people have talked about in the morning of recidivism. People re-offending all the time. And you know, as the court, if you keep doing the same thing, then you should also ask yourself, how to borrow on wakirudi? And that's the question I asked for Wanjohi's case. And so what happened, at the point when I saw the pre-sentence report, I sent the file to AJS. Huyu ni mtu ameitikia makosa, amekubali. So this is not the traditional referrals you would do. Hata ana shida, hata ameitikia. And so they went and I actually found them one afternoon in one of my courtrooms. They actually did it in court because he was in custody. I found Wazee, then I just waved and passed by. But it was one of the most beautiful things we have done in court. Those people sat down, talked and found out what is the problem. Something very interesting. This complainant, Mzee kabisa, is the oldest man in the village. Ule unajua tu ukichuna avocado zake atakuangalia tu. Okay? So he was the easy target. And so this man would keep going back to him. The community sat down and saw how to resolve this issue is to empower this young man, Wanjohi. Paka tafutio kitu inafanya. And there's need for us to rebuild the relationship between these people because the complainant is a very bitter man. Mtu anakuja kila wakati na ni mimi ananitarget. Okay? So that outcome, when it came, they found a way. One of the elders actually offered, I think it was a very well-off, what was that? Okwangi Obaya, what Emilio Kibaki Okwangi Obaya, offered even to give him work. One elder, I remember, offered to do ambuzi. I don't want to kuharibu a culture of Kikuyu, but they did ambuzi. There was goat eating. Someone offered to do it and sort of and rebuild that relationship between these people who would still live together beyond the court. I cannot offer that. I promise you. Hata nisikie hiyo kesi aje. Na huyu mtu wa makadami hata ningemtuma jela 30 days. Angerudi na angerudi wapi? Kwa huyu mzee. Sikuona Wanjoi tena kotini. Sikumuona. And that is the work that the elders are doing. I want to quickly talk about people with mental illness. Nyinyi wote mnajua, if you have a person, and most of us, sahi tutakubali kwamba at least somebody in our family kuna mtu ana mental issues. Ni kweli? And for a very long time, people have used the criminal justice system kupeleka watu hospitali. Ni ukweli ama ni story ya ajabu? Si ni ukweli? So there's a gentleman who's brought to me. The offense haikuangi serious sana, ilikuwa creating disturbance, amekimbiza mama na panga kwa boma, and is brought to me. Ukimwona tu unajua huyu kuna shida hapa. Of course, you go and send for a mental assessment report. It comes back, this person has a mental illness. Sometimes it's permanent that they will never resolve it. Unfortunately for this accused person, it was COVID time. Mathare imefunga milango, they are not admitting anyone. We were left with this gentleman between the court and Nyeri prison. He stayed for 9 months. It bothered me because I have very few remandees. I know them by face and by name. What can I do for this poor person? Because the most he can do is to go for clinics and come back. Go for clinics and come back. At some point, we decided with the prosecution counsel, let us relook at this file for this gentleman. We called the family. We say this will have to go to AJS. Let us find out what the problem is. Because between me and you, we know it's an issue of non-compliance. No one is giving this person medicine. No one bothers whether he does his clinics or not, which if he does, he would not be in court. Sindio, atakuwa amemanage his illness. And so part of what was done with the elders was to find a structured way in which the family would take up the responsibility of ensuring that he takes his medication, one, he has medication, and he attends clinic. And even before we say that finally the prosecution now decides they're going to withdraw the charge, we gave it time to see, is it working? To come release wenda nyumbani, come after 30 days. Come after another 30 days, now we are ready. Prosecution, you can move the court as you please. Nobody will force you to withdraw, but it's the language that the court and the prosecutors understand each other very well. So I am just saying this, that there's a beautiful thing about AJS. It's that it's not cast in stone. It's not a mass it's done at this point. It's not a mass it's done at plea taking, or where parties have disagreed, have not pleaded to the charge, or whether they have pleaded. You can use it at any point. Judges have endorsed this. Judges agree with this. And let me tell you something, in the long run, everybody is satisfied. If you serve, like the great people over there that we served for that period of time, the number of pleas that even come to court are on the minimal, and that is the truth. I went up to some point, would get to almost 500. Nasema sasa tutaweka category gani ya cases? Kazi yetu inarudi chini sana. You understand? A funny concern, but it's very interesting to note that where AJS works very well, even the work that is pushed to come into court is very minimal. I will close with Odaya and in 2 minutes talk about Gishugu. My moderator, you can smile at the screen. I'll take a very short time to talk about Gishugu. So I moved to Gishugu, and what I found in Gishugu that is being practiced, and I hadn't practiced, is plea bargaining. I want to appreciate, I don't know if Lenson is in the room, he's not here. He did some very good work with the US DOJ. I hope I've captured it correctly. In Kirinyaga County, they have preached the gospel. They pulled in and roped in all other courts in the county. They have gone to the prisons and preached the gospel of plea bargaining. I have not been trained on plea bargaining. I trained myself on the job, on what I need to do. I was given that questionnaire that I was talking about. I learned a procedure myself, and I'm very happy to do it. It is excellent. The only problem that we have is it is not so much being consumed by people who are out on bond. I think it's more in prison because officers will talk about it. We talk about it also in the prison mentions, and the uptake for the people who are out on custody, out on bond, is not as high as those who are in custody. Excellent work. Thank you, the DPP. This is flowers to you. We also do diversion. We also do Cotanex mediation. We are now working towards launching our AJS. I thank Mr. Washira and Mr. Githaiga have already come and helped us to talk to the elders who have been identified as practitioners in our jurisdiction. We look forward to working with the Secretariat, Ms. Aluda and the other team in just setting up AJS in Gishugu. I really, really thank you all for listening to me. I thank you, gentlemen and ladies who are doing the work on the ground. Ukitoka hapa kitutajisikia tu. We appreciate you. We respect the work that you do. Please do not sit one time and say, does the court trust my work? I am telling you, as a judicial officer, I've done this over 6 years. Take that from me. Having said that, I'll stop at that point. I thank you all for listening to me. Continue doing the great work that you do.
Excellent, excellent, Honorable Mnyendo. And thanks for highlighting your work. Can you give us the example of what was that boy again? Huh? Wanjohi. And just giving us, opening our eyes that sometimes the sentences that we pass do not really meet the justice needs of the person. And the question asks yourself, whose justice are we seeking? But also just reiterating that sometimes when the matter comes to you as an assault, as a murder, you've not even dealt with the issue back at home. And sometimes the issue is just very small. But tunapata watu wamepigana, wamekatana, kidole imeanguka leo, kesho ni mkono imetoka, kesho kutwa sasa ni mada. Well, kama judicial officer kikuja, I always ask people, what kind of evidence do you need? P3 form, medical report, statement you're accused, and that's it, to convict. But have you dealt with the issue? So the importance of us to be very innovative, even as magistrates, because sometimes you just have to stop writing and ask yourself, what is the underlying issue? Because as you continue writing, you forget to deal with the underlying issue. And you've really highlighted the real case examples that we're dealing with in the society and in the community. And sometimes going to court may not really resolve the issue. And when you come back at home, ni hao tu, ni familia yako bado na deal nayo. Let's clap for her once again. Yes, Isiolo.
Yes, asante. Kwa majina naitwa Abdullahi, Sergeant Abdullahi, welfare officer Isiolo Prison. Yale ningeongea mengi yamesemwa, lakini naongezea moja mbili. Nikaanza nalo, roles of a prison officer, ni AJS. Kazi ya prison officer ni nini? Manake sisi sio AJS practitioners, lakini we have a big role to play. As a prison officer, the role is security and safeguarding of the AJS practitioner, the inmate, and the complainant. Why am I saying so? Watu wamekosana na wanakutana ndani ya prison. Kitu ya kwanza, hatutaki na hatukubali, ambao sijawahi kutana nayo, AJS practitioner alete marufuku ndani ya jela. Lazima tunaangalia hiyo. Ya pili, tukileta watu pamoja, hatujui what will happen in the process. Because nimewitness mahali ya kwamba the complainant anakuwa na hasira, anaanza kupiga. The accused anakuwa na hasira, anaanza kupiga the complainant. Kwa sababu gani? Wakati kesi inafanywa ni kama mahakama, complainant anaulizwa ile kitu imefanyika. Kwa ile process, pengine anakuwa maybe the accused anakuwa embarrassed, anaanza kukuwa na hasira, kuwa violent. So as a prison officer we intervene. Tunataka usalama ya mfungwa na mlalamishi. Na lazima tunakuwa standby ya kwamba hatujui nia ya complainant. We don't know. maybe ako na intention ya kuja kuona hii mtu kumpiga. So kitu cha kwanza tunafikiria usalama ya both parties. Kazi yangu kama prison officer ya pili ni ku identify inmates eligible for AJS and link with elders and paralegals AJS. The process yanze. Utaona I'm a counselor, I'm a welfare officer, nafanyia counseling wafungwa. After they were admitted to the prison, the next step is my office. So when they come, mimi nauliza maswali, ulifungwa nini, kosa lako ni nini? Nikiona ni petty offense, namwambia nipatie namba ya the complainant. Are you willing kusameheana? Ndio. Kama mwingine anakuja anakuambia the complainant is my parents, my relative, so welfare naomba upige simu nini. Ama our paralegal officer ana identify cases, anakuja kwangu ananiambia pigia hii mtu simu, ako na kesi ya AJS. Mwingine ni kwamba court inatuma order through council of elders, a council of elders ananiletea, and then I look for the complainant. Tukipata tunaleta pamoja na kesi endelee, and then the council of elders will write this report to the court. Wengine hawajui, we educate them about AJS opportunities, and then finally we contact the complainant. Wakikuja pamoja inakuwa ndio sasa sisi tunapeana security na tunaangalia na kesi inaishia hapo. Mingi imesemwa, ningesema lakini sitaki kurudia ile kitu, na niko na concern. Cases zingine hazina complainant, ambapo the complainant is the state. Where I'm coming from, kuna foreigners like Ethiopians. Kuna petty offenses like fail to register as a Kenyan citizen. His case unaona ni petty offender. Who is the complainant? Utafanyia namna gani? Hiyo ni moja ambapo inanisumbua mimi my level or at my station. Manake as we are speaking, we have 57 Ethiopian prisoners in Isiolo prison, ambapo Isiolo imepakana na Ethiopia. Wanakuja sijui wanaenda South Africa, wanashikwa hapo katikati, wanaletwa hapo prison. So petty offense, lawfully present in Kenya, lakini huwezi jua utafata mondo gani kusaidia hii mtu. Mwingine mtu unaona anafungwa miaka 3 ama anapewa fine ya 200,000. Ni unlawfully present in Kenya. Kesi kidogo kama hiyo. Mwingine ambapo imenisumbua ni ya kwamba cases mingi watu inakuja kotini kwa sababu ya hasira. Ukikuja kwa hasira, mtu anakataa kuja court. Adjournment. Baada ya amekaa miaka 2 remand, ndio pengine mahakama inamwachilia. We also need civic education. Watu wetu wanafaa kuelezwa mambo ya AJS. Challenges ya kwamba vile mwenzangu Kitonga alisema, nilipigia complainant vile remand prisoner amenikujia niambia kwamba naomba nisaidie kupigia nani complainant yangu akuja aongee na mimi ndio tuelewane. When I call the complainant amenileta juu, ananiambia mimi nitakushtaki na nitakupeleka kotini. Nimejaribu kujieleza mimi ni nani, hakutaka kusikia. Baada ya amefika police station, nimekuwa summoned by the OCS, and then I just explained to him. Ilikuwa imeeleweka. Mwingine ni kwamba watu wengine cases like create disturbance. Mtu mwanaume ni mlevi, anasumbuana na bibi ama anapiga bibi, anakasirika, anafunga. Niko na case, mama amenikujia juzi. Niambia hii mtu nimefunga yeye out of hasira. Na sasa hii inaumia na watoto. Nisaidie kwa kesi iende kwa wazee. Mtu ashafungwa. already convicted. What do we do? Hujui vile utafanya. Na ingine ni ya kwamba kuna kesi ingine pia niko nayo, a guy from Eldoret ameshikwa hapa Nairobi. I don't know what happened, amepelekwa Cielo. Alikuwa anafanya company, ameiba around 2 million. Jamaa amefungwa miaka 3. Kufungwa miaka 3, ananikujia last week, alinikujia akaniambia welfare, mimi maisha yangu iko hatarini. Tuli hatarini aje na huko jela? Kwani askari ya jela ndio wanataka kukua? Hapana. Anasema the complainant is monitoring my movement. Ile mahali mimi naenda yote anataka kujua, na hata amejua wakati mimi namalizia kifungo. Amesema hiyo milioni yangu 2 haiwezi enda hivyo. Amefungwa, is serving, bado anakuwa threatened toka nje. Hiyo ni kusema nini? Ni kusema ya kwamba the complainant hajaridhika na hukumu ya mahakama. Laiti watu wangeletwa pamoja na isuluhishwe, ingekuwa hiyo mtu hangekuwa na hiyo shida. So mimi nasema, mimi mahali nimetoka, wacha hii bete offender saizi inasemekana. Sisi hata mada kwetu, mimi amwaki ni Isiolo, mimi kwetu ni Wajir, mimi ni Somali. Kwetu hata mada inafanywa AJS. Sisi mambo ya mahakama ndio sasa ndio tunajifunza. Hata hatukuwa tunajua. Mada na mimi hata nakubali, hata pengine mnaweza shangaa. Hiyo ndio afadhali kuliko kufunga mtu. Kwa sababu gani? Mtu ameua mtu, au watoto wamekuwa yatima. Hakuna ile mtu atawasaidia. Na ile mtu mwingine ambapo ameua mtu amefungwa, tuseme amekuwa condemned or life in prison. Both families are suffering. In our case, ikihappen kitu kama hiyo, wazee wanakaa, mtu anapigwa fine 100 cows or camels. Ngamia 100, unapigwa fine ya ngamia 100. Hao watoto wamepata mali ya kujisaidia juu wamepoteza baba yao, na huyu bado wako kwa familia yake, anasaidia watoto yake. So AJS sisi kwetu ilikuanga mpaka saizi iko. Saizi ile kitu saizi kwetu imefanya inaletwa cases kotini ya kwamba wanaogopa polisi. Wale wanaogopa polisi wanasema hiyo kesi kisikika na chief ambapo mmemaliza nje ya mahakama, chief ataripoti kwa polisi, shikwa. Hiyo ndio inafanya watu wetu siku hizi wanaleta cases kotini. But initially hakuna kesi ilikuwa inakuja kotini. I'm sorry to say so, even sexual offenses. So AJS is a win-win to both parties, the complainant and the accused. Kwa hayo machache nasema asante.
Thank you very much, Abdullahi, for highlighting how AJS is working in Isiolo. Penye mmetoka ndio ilikuwa mbali, hatukuwa na mambo ya polisi, but now that you have been training and on areas on which cases you can handle, especially SGBV defilement, so at least that's when nasikia tunasema tuende kwa polisi. It just shows that the kind of advocacy that we've been doing, but we applaud the work of AJS. But you've raised good concerns which Julia has taken note of, dealing with the wanaitwaje foreigners, especially in these petty offenses. Sometimes amesentencewa kwanza for Ethiopians, they don't even eat our food, so the prison has to find the food for them, which is very difficult. But also people who are in custody, the ule complaint anakwambia hata ukitoka bado utalipa. And this not only on obtaining matters, even in murder cases. Unaambiwa skula taachiliwa, lazima to deal na hiyo issue. But you violated one thing that one quote I like, and I'll just read the quote. One weekend we have them sleep it off in the emergency room. So the emergency room is like the cells where we take our prisons, where we take the people in to arrest, pre-trial. Then the next weekend they're in jail. So next weekend means on Monday tumapeleka kotini, wame plead not guilty or guilty. By weekend wako jela. So you can look at that and picture yourself in Kenya. The next weekend they're on the Kone psychiatric unit. He said that hiyo ndo kazi yake, so that's why he had to pick this out. So wametoka kwa cell, police wamekuwa sasa kwa jela, then the next weekend sasa wameenda kwa psychiatric kuambia don't worry, God is with you. You get now
the preachers of prison. God is going to visit you. They visited Paul and Saul. Prisons would open. Here we count one day, one night. So they tell you everything. Then after that, we ship them to Warm Springs. Warm Springs means we now take them to hospital. They can't handle it anymore. How do we look at the system and get people into the right program so that we don't see recidivism? So we need to just rethink about issues of incarceration from the cell to the last one. The last quarter, actually, like seeing firsthand some of the conditions to subject people to in these facilities, emphasize how you must urgently end our overreliance in incarceration and embrace new visions for public safety, accountability, and rehabilitation. This is Winnebago County District Attorney Eric Spa. So you were saying, if you look at the conditions that people go to, from the cell to prison, kwa hizo rooms zenye anasema, we need to see how we need to address overreliance on incarceration. Asante. Let's hear Masaku. We give a clap to Abdullah once again.
Good afternoon. My name is Davis Michael from Machakos. Though we work for the greater Machakos, Kitui, and Makueni, I wonder what to say. Having heard from Yuli and the senior principal, the starter of NJS, Kidaiga, and the welfare officer, they have almost summarized what I would have said. But I want to just to add 1 or 2 points. One, we from Machakos, we were trained by our good friend Fida many times, and many times we were on the civil matters. In the first place, we never dealt with the criminal cases because we were told those were not on our areas. And I want to say on the civil matters, wonderfully, we have put our area into a good pace on issues like land disputes, land ownership, small issues like boundaries. The only major problem now which we are facing is on succession, where once a person passes on, then people fight over the estate, and this also may lead even to fight, death, and then instead of decongesting prisons, they go to prison. So that is one area which we have not yet begun. However, of late, when we had the last NJS conference at Kabarak, we were told we can handle some of these cases, and therefore we have begun handling them, especially these petty cases. We involve the area chief, the nearest police office. We have these people meet, we discuss the matter with them, and many times even the cases don't go even up to court. In the case a case, we are unable to solve it, and somebody becomes defiant and takes it to court, then we also go and follow it up there and say, let the case be brought to the elders. The once it's brought to the elders, we convince the offended person, and many times we tell them the advantages and disadvantages. In Ukambani, we have a way of compensation. If you harm somebody, there is a way we compensate. Those who are from Machakos and Etuia, they know there is that in Bai, and then there is this Mambo, and how we pay, depending on the harm which was done to you. And we formed a constitution. We have a book which we have written. Once it is done, this is followed. And many times now are following. And there are most of these petty cases nowadays, we are solving them, and we are happy that people are accepting. We have a few challenges. There are people who do not recognize NJS, and there is need of civic education. The arms which are concerned, the judiciary and the police, plus the interior government, should sometimes assist in sensitizing the people that there is AJS. These elders, in the first place, elders were thought as people who may be useless. But in fact, from time immemorial, even before Mzungu waje Kenya, the elders were there and they were doing their work. And therefore, to erode their responsibility not to be proper. And for this matter, my appeal is the judiciary should recognize. I don't want to say so, but I don't know whether all courts recognize AGS. Unaenda huko unapeleka unaandika barua, you say you want this case to be sit on us, and some of them get them like ELC cases. The elders know much about the boundaries and this massive issue of disputes in the family. I don't know, they don't know more than the law, but they are more inside knowledge about what happened. And therefore, my appeal is, if the judiciary and then the members of the interior government, that is the chief and the rest, and those concerned, even police, if people are told so that if a matter comes to you, you know which right place to go. I want to say one good example. There's a place we call Konza, where the OCS and the crime officer are very much concerned. If a matter reaches them, they wear it very much. Then they call the elders, we go, or we go to them, then we solve this one. And this has very much helped us reduce crime in our area, as not many people going to prison. We had a young boy who was giving a lot of problem with the village there. And then we sat down, I can call him the Kichugu of that area, and we look to find out his problem. Because after every 1 to 3 months, another prison, and arudishwa nyumbani. After another time, alafu tukakachi tukaona, what is wrong with this boy? What does he lack? Tukaona he just wants empowerment. And the elders and other people find out how to do. He has opened a kiosk, and is a good, reliable person in the area. Therefore, there's need of these people getting the knowledge and having it very much. Therefore, lastly, involve them. Those who can be trained, let's have trained people, because lack of knowledge, you cannot handle people. And the last and not the least, I don't know that the judiciary and advocates, most advocates, when they hear that AJS and this case, they start shivering. How can you take over our bread? This is the major problem we have. Unaenda kotini unasema hii kesi unataka iende, unakuta watatu wanakuja to represent somebody, yet it was be a elders issue, yet the advocates are coming in. As soon as somebody comes up with a solution, the better for this country. Otherwise, AJS is the solution of problems and the mitigation of cases. Thank you.
Let's clap for our panelists this afternoon. Tupige makofi tena. Let's stand up for a group photo. I believe it's been an awesome lesson, especially taking us back to the conference, that indeed the conference was very impactful and they were able to expand just beyond what they're dealing with. But as you can see, we have those people who are petty offenders. Tunaona kama ni petty offenders, ndio? But in this sense, they're only required to be empowered. And that's good work that we did. Ngoja kwanza pia mimi niingie kwa hiyo picha. I missed the photo. Excellent. Tupige makofi wanaporudi katika kuchukua viti vyao. We've heard from reforms and the need for us to reform some of the policies. We've gone to practically how AJS Court Annex is working. The magistrate told us about innovation and how she has been innovative in terms of dealing with dispute. But mnaona Othaya unakuwa na 4 inmates. Mpaka watu wanatolewa kwengine wakiletwa. Wengi wanatolewa kwengine wanaletwa kwa sababu the prisons ziko empty. We've also heard about the experience in Isiolo, but more importantly, we need to think beyond just our own. Foreigners wanakuja, inmates hawako safe. Yet tungekuwa tumeombe discuss huko nje, hawangekuwa nayo. Bado uko ndani lakini unaona kama hauko safe because somebody still feels like justice has not been served according to him or her standards. Then Mzee has just told us how the innovation is working and how the need for us to be able to think beyond what you're doing. Lastly, we are going just to have like 20 minutes or 30-minute session of now 2 people. They're coming in pairs. They're 3 pairs. Solo, Kitui, and Elda Maravi. can start with with the general council that we just compliment. The two pairs. Karibuni, first. So let's hear them, how they felt when the matter was. Trying to be a Kenyan. Yeah, I've tried not to be a Kenyan. Trying to be a Kenyan. Yeah, I'm supposed to be a Kenyan. Media team, can you please check the battery? Maybe tumeongea sana, maybe ni battery. Okay, so therefore, two pairs, a pair. Okay. Kuna mtu amekosa kiti. Okay, we are good. Okay, let's be seated. So make it brief. Sasa utakuja huku. Hai. Beneficiary tunaonaka. Okay. Then Gashisho unge take charge. Yeah, please.
Good afternoon. God is good and all the time. Yeah, I would like to take this opportunity to say the Isiolo elders kindly come forward because we won't have time to introduce you. Yes, Isiolo elders. Kitui, sorry, Kitui. You are an elder? Okay. Beneficiaries watabaki. Just your name.
Asante. Mimi naitwa Fredrick Kinaro Maina. Nimetoka Isiolo. Mimi niko katika kamati ya AJS nikiwakilisha the community minority. Najua Kenya tuko community 42. Isiolo kuna 5 major community. Hawa wengine wote nabaki kutoka 42. Mimi ndio nawakilisha Isiolo kama chair.
God is good all the time. Robert Kusinga kutoka Mutomo, Council of Yoda, chair tunafanya na Gitonga huko.
God is good and all the time. Kwa majina Julius Mtunga Kivuko, tunafanya Kitui Mutomo na our officer wa Mutomo Kiboya, Justus Kidonga. Mimi ni katibu wa AJS. Asante.
Mjambo, jina langu ni Bishop Dr. Steve Kalunyu, mwenyekiti wa kamati ya Meru Community AJS Isiolo County.
Asante sana. Kuna mwingine elder tumewacha? Ameketi? Sawa, tuwe na sasa Elder Maravini elders wakiongozwa na chief introduce watu yake, alafu tubaki na beneficiaries.
Hamjambo. Kwa majina naitwa Suleiman Omar. Mimi ni naibu wa chifu kutoka pale Baringo, Eldama Ravine. Na in Eldama Ravine, Baringo County, we have embraced AJS. Actually AJS imekuwa na faida kubwa sana kwetu. Mojawapo imeleta utangamano mzuri sana baina ya watu ambao tunaishi nao pale. There is one case, a scenario ile tulifanya in our last sitting. A very senior officer, a county commissioner, alikuwa na mtoto ambaye alikuwa anamsumbua and he was convicted for 2 years for creating disturbance. And then the case was brought to the AJS na tukaweza kukalia and we were able to exhaust the problem yenye ilifanya huyo kijana asumbue from the time alikuwa secondary school. Tukajua ya kwamba alikuwa na mambo ya drugs na kuna vile wazazi walikuwa wanamwandarate kwa sababu the other children are very much successful na wengine wameenda hata nchi za nje, wako Australia, Canada. This one is being underrated by the parent, ndio anajaribu kuwa rebel. So wakati tulipojaribu ku exhaust hizo shida ambayo kijana ako nayo, tuliadvise vya wazazi jinsi ya kuhandle huyo mtoto like the other children, and as we are speaking now that person amekaa vizuri sana na baba yake na hata amefunguliwa biashara, and even the parents are contemplating to send him abroad as well. So AJS is working as it is causing peaceful integration na watu waweze kukaa pamoja. Another good thing with AJS, inaleta win-win situation. Mtu all the parties wanaweza wanapata ya kwamba wamepata justice, lakini to the other court system sometimes mtu mmoja ndio anapata justice, mtu mwingine anaona ni kama amedhulumiwa. And then pia AJS ni timely, within this one sitting kesi inaweza kukaliwa na solution imepatikana, advice imepatikana, na watu wanaweza kukaa katika hali ambayo ni maridadi. And then also promote respect to the elders. My elders, for example, in my sub-location, I have more than 40 elders. Since the inception of AJS in my area, wazee wameweza kuheshimika. The time nilikuwa kwa ofisi, in a day, ningekuwa na kesi kama 5 ya cases, disputes, family disputes, nini zilikuwa zinaletewa kwa ofisi. Lakini wakati AJS ikaletwa, we train the elders, wazee wakaheshimika, pale kijijini wazee wanamaliza maneno pale pale, na watu wanaishi vizuri in peace and harmony. In the AJS, sisi tuna handle both criminal and civil cases, na kusema kweli, if I'm given time to speak about the benefits and the merits of AJS, I will speak up to saa 4 ya usiku about the merits of AJS. Otherwise, because of time, AJS sisi kama wana Baringo tumefurahi. All the stakeholders ambao wana fund AJS, endeleeni kufund, tusaidie tuendelee kusensitize wananchi kuhusu mambo ya AJS. Ile AJS ambayo tunafanya pale Baringo, tumesaidiwa sana na paralegals, and especially hii organization inaitwa LRF, Legal Research Foundation, ambayo inakuwa sponsored na Diakonia and the Swedish government. Sisi kama watu wa Baringo, we appreciate what you have done to Baringo. Na LRF stay in Baringo, sisi tunawatambua, Diakonia tunawatambua, na kazi ambayo mnafanya tumetambua, na Mungu awabariki na muendelee kusonga mbele na mbele zaidi. With me, I have come with some few elders. Who are very much trained. Tuko na madam hapa, atawasalimu tu kwa haraka, aseme jina lake.
Jambo. My name's Alice Ayabe. Mimi ni AJS practitioner, prison model. Nashukuru kwa sababu ya hii jambo ilipoanzishwa. Actually tumeenda mbali na tunashukuru. And let me say, tunapata enough attention kwa kotini, tunaheshimika, tunasikia mzuri. Mungu awabariki sana. Your colleague Mr. Ombea and Mr. Koech, Honorable Koech and Ombea, actually they give us all the attention and whatever we require. Honorable Kiturians, what we require. Thank you very much.
Niko na mzee mwingine hapo.
Jina langu ni Dhuku Washira na tunafanya kazi na chief na we are well trained, na tuko AJS ya Eldama Ravine na tumekuwa attached na prison practitioners, na tunamheshimu sana madamu wetu Florence, sababu tangu aingie kwa hiyo kwa hiyo kasi ya kututrain area hiyo, hata uwezi na mambo mengi sana imepungua, na tunashukuru sana. Ametupea training ya kutosha, na mpaka akatutuma huko Baringo headquarters tukatrainiwa na Dr. Okoth siku 2, na tunamshukuru sana sababu mafunzo yake ni ya hali ya juu sana. Kwa hivyo ni watu tunaheshimika huko, na tunaendelea na kazi na tunasaidiana kusaidia jamii na kushikanisha jamii ndio siweze kuishi pamoja, na upungufu wa mambo mengi ya uhalifu na nini inapungua sana. Asanteni sana.
Through AJS also there were couples who were fighting. Husband alikuwa anasumbua wa bibi yake sana pale Eldama Ravine, mpaka anakojolea sufuria, anapiga watoto, anafanya nini. Time he was convicted na alikuwa amefungwa kwa mwaka 3 kwa hizo kesi, lakini ikakuja ikafanywa referral, ikaletwa kwa AJS, tukaweza kuzungumzia. At the moment bwana na bibi wamekaa mzuri. Bwana alikuwa mlevi, amewacha ulevi, sasa amekaa vizuri na bibi. Even as we are speaking now, the baby is pregnant and we are very happy. The family imekuwa integrated again. And through insights and motivation from LRF and especially from Madam Florence Gashisho, mimi personally nimependa AJS kwa sababu imesaidia watu wangu. At the moment I am taking a course, diploma course on AJS. Nita graduate December hii kwa ajili ya kazi ile. Ninaona watu wangu wakifaidika na naona mambo mazuri yako mbele kwa AJS. Kwa hivyo tunatamani. Asante sana.
Thank you so much, Chief Omar. As you saw, the Eldama Ravine is also a cosmopolitan town or area. We have majorly Kikuyu, the Kalenjins and Nubians. So we are happy that the elders are integrated from all the community. We also have a prison liaison officer. Just wave to the crowd. Yeah, his name is Kiare. He's the liaison officer between the prisons and the court. We shall now start with our first pairs of beneficiaries. That is from Baringo County, Mumberes, introducing Bernard Rono Kiplimo, who is a complainant, who is the accused person or a convicted person. He'll narrate his case, and the complainant was his brother and the mother. Karibuni.
Amjamboni wote.
Simama. Ama uko sawa hivyo? Haya.
Majina ni Bernard Kiplimo Rono, natoka Timboroa, Baringo County, Eldoret constituency. Niliweza kushtakiwa kwa kesi ya uharibifu wa mali na kutishia maisha na mama yangu. Niliweza kwenda kotini, sikuwa nimegundua ya kwamba mtu unaweza kana alafu bado ukaekae pale rumandi alafu usolve issue kupitia njia ya AJS. Nikaenda nikakubali pale kotini, niliweza kufungwa miaka 4. Nilipofungwa pale ndani, Madam Kashusho, Legal Resource Foundation officer, niliweza kumpara pale ndani akiwafunza wenzangu kuhusu AJS, njia mbadala ya kuweza kusuluhisha kesi dhidi ya familia. Niliweza kumapproach na aliweza kuwaita complainants wangu ambaye ni mama na ndugu yangu na pia na wazee na the prison authority kaa chini, na aliweza kufanya sentence review na akatumanisha pale kotini na hiyo ripoti ya elders niliweza kusikizwa. Baada ya hiyo nilikuwa nimenyenyekea na kuomba msamaha na niliweza kusaidika kupitia kwa hiyo njia ya AJS. Mimi mwenyewe ni ushuhuda kamili, na mpaka saa hizi tuko pamoja. Huyu ni ndugu yangu ambaye ni complainant wangu, tuko pamoja pia na mama mzazi. Nashukuru sana AJS through Legal Resource Foundation. He can bear the real truth. He is my brother.
Na wasalimu wa mjambo. Kwa majina naitwa Philemon kama vile ambavyo naweza kusikia. Mimi nilikuwa mlalamishi, tulikuwa wawili pamoja na mamangu. Bernard Kiplimo ni ndugu yangu, ni mrefu kwa kimo lakini ni mdogo wangu. Alifanya vile ambavyo alifanya, aliandikiwa 2 counts, threat, number 2 malicious damage, na kulingana na sisi kwa sababu yeye hakuwaifanya makosa hapo awali, lakini wakati ilifika pale ikawa ya kwamba ikabidi amehukumiwa, na sisi tulikuwa tunafikiria tu atapewa discipline peke yake ile ya kawaida ya miezi 6 hivi ama miezi 3, lakini all of a sudden tukastukia tu amehukumiwa miaka 4. Baada ya kuhukumiwa miaka 4 kuna yale mambo ambayo yalifanyika. Number 1, kumbe tulijua ya kwamba kumbe uchungu wa mama ndio huwa anajua sana. My mama akakuwa psychologically disturbed na hata kwa amemaliza 3 months na alikuwa amempeana apewe discipline. Pia kama ndugu yake nilikuwa na feel ya kwamba ni kama sijamtendea haki kuweza kumshtaki. Nikaanza pia kusumbuka, na kutokana na yale ambayo watu walikuwa wanatuambia, tulikuwa tunaambiwa ya kwamba mtu akishafungwa ni vigumu sana aweze kufunguliwa, na nilikuwa nashangaa huyu jamaa akimaliza miaka 4 pale ndani tutakuja kukaaje kama ndugu mmoja. It was until wakati nilienda prisons nikakutana na Madam Florence na tukaongea na yeye, tukakuja tukafanya mkutano pamoja na yeye, mama akakuja, tukakuja mpaka na elders, tukaketi pamoja na the prison authority, tukaketi pamoja, tukazungumza, tukapiga picha, alafu Madam Florence akaniambia uniachie the rest. Kwa hivyo kama vile ndugu yangu ameweza kusema, ndio huyu yuko hapa, tumetangamana pamoja na yeye tena baada ya mwaka 1.5, na ni kwa sababu ya hii program ya AJS ndiposa ndugu yangu yuko nyumbani siku ya leo na mama ameweza kupata nafuu. Mungu awabariki.
Wow. Thank you so much, our beneficiaries from Baringo. We now go to the next, our beneficiary from Mutomo. Isiolo.
Habari yenu. Kwa jina mimi naitwa Martin Odiwara Koko from Homa Bay County, Nyanza. Kwa kazi nafanya kazi Isiolo. Mimi nafanya kazi ya kutengeneza magari. Tunafanya Isiolo. Nashukuru sana siku ya leo kusimama mbele yenu. Juu hii maneno ilifanyika. Kuna rafiki yangu hapa tunafanya naye kazi moja. Naitwa Mtweri. Sasa tulipitana kidogo tu mambo ya kazi. Na sikujua kama nimefanya makosa. Kumbe yeye aliona ni makosa. Sasa yeye akaenda akaripoti. Mimi nikakuja nikashikwa. Nikapelekwa Central, nikatoa Central, nikapelekwa Main, nikalala siku moja, Thursday nikapelekwa kotini. Kotini nikaenda nikapelekwa remand. Nikaenda remand, nikakaa. Sasa story venye remand mtu anakuuliza nini imekuleta, nini kesi gani imekuleta hapo umefanya. Mimi nikawaelezea. Sasa nilisema nani naweza nisaidia hapa, kuna kesi hapa naweza nisaidia. Nione kama naweza pata huyo complainer yangu tuongee naye juu alikataa kuongea na mimi huko nje. Sasa kuna jamaa aliniambia kuna paralegal anaweza kusaidia na hiyo kesi. Sasa unajua huko asubuhi unafunguliwa saa 2. Saa 2 hapo ndio unaweza pata chance mpaka saa 4 na dakika 20. Ndio tena unarudi ndani mpaka saa 9. Sasa venye asubuhi nikamwambia wewe jamaa unionyeshe huyo paralegal mimi niongee naye. Akanionyesha, nikaenda nikajieleza, nikamwambia shida yangu, akanituma kwa welfare. Nikaenda kwa welfare, nikamwambia welfare niko na namba jamaa complainer tulikuwa nayo, tulikosana nayo, niko na namba hapa, nataka akuje tuongee hapa na paralegal. Nikapeana namba, nikarudishwa ndani. Siku 2 nikakaa huko ndani. Mimi nasikia kama hiyo siku 2 nimeitwa. Nikaenda nimepata wazee na paralegal kama wako hapo na huyu complainer. Tukakaa chini, nikanyenyekea mbele yao, nikaomba msamaha. Wazee walinisaidia. Paralegal kuna barua aliniandikia, kaenda kotini. Siku nilienda kotini, jamaa alikuwa anataka 7,000. Nikamlipa hiyo 7,000. Sasa wakati nilienda kotini, mambo yangu ilikuwa rahisi. Sikuongea, sikufanya chochote. Complainer yangu aliinua mkono, nikaachiliwa. Nashukuru sana paralegal na wazee. Asanteni sana kwa kunisaidia, niko nje, niko sawa saa hii. Asanteni, hiyo ndio mambo yangu.
Thank you so much. Tusikie kwa the complainant.
Habari zenu. Mimi naitwa Eric Manyata. Mimi na Martin tunafanya kazi moja. Sasa mimi nilipigiwa simu na ndiye alitusaidia sasa kama baba yetu.
Asante sana. Tunaomba mhubiri hiyo AJS kwa vijana Gen Z kama nyinyi. The last beneficiaries, karibuni.
Asante. Nataka kusalimu nyinyi wote katika jina la Yesu. Hamjambo. Majina mimi naitwa Pastor Ben Rogers Kiveka toka upande za Mutomo. Ningependa tu mnipe time kidogo niongee kwa sababu niko na mengi lakini sio ya pastor. Mwanzo nataka kushukuru Mungu sana. Mimi sikuwa ninajua mambo ya NGS, nimejua leo kweli mzuri. Na nimemshukuru nyinyi sana. Kazi ambaye nimesikia hapa katikati yenu ile mnafanya ni mzuri sana. Nyinyi mnakaa kama Mungu. Na ninasema hivyo kwa sababu mimi ndio nilikuwa na complain kufanyiwa mabaya na mwenzangu hapa. Kuna siku moja ambaye nilitoka kwa nyumba nikaenda kwa ngali na nikakuta ngali imefunguliwa. Kuangalia nikakuta imetolewa betri, na saa hiyo nilikuwa nimetoka town, nilikuwa na simu za wafanyikazi wangu. Nikakuta tena hakuna, zimeenda. Sasa wakati niliona hivyo, mimi ni mkulima. Mimi hata sikuambia bibi yangu. Nilitoka tu na hasira na kuona, nikauliza Mungu, kwa nini umewajilia waizi wakakuja kwangu? Na mimi hii sasa mimi naumbilia waizi waokoke. What happened? Mimi nikakasirika sana na nikaenda shamba. Nikiwa kwa shamba nikapigia mama. Kamwambia hebu angalia kwa kuangali. Kamwambia angalia kwa Nissan. Pika ilikuwa imefungwa ingefunguliwa. Alikuwa ametoa kwa Nissan. Kamwambia angalia kwa Nissan ya 10 na betri, na simu zile zilikuwa za wafanyikazi hakuna, na mimi niko kwa shamba. Sasa mama akaenda pale akaangalia. Kitambo hapo akaangalia akakutwa na kijana mwingine alikuwa kwa scraps. Akamwambia kuna mtu niliona hapa. Nilikutana naye akiwa anapepa hivi na hivi na hivi. Na ni yeye, akamwambia jina. Sasa wakati nilikuwa mama akanipigia simu akaniambia fulani ndiye alionekana akiwa amebeba hivi na hivi. Kwa hivyo wewe kuja ndio muone vile mtafanya. Mimi sikuharakisha. Nilikaa kwa shamba, nikafika tomato dawa, nikamaliza saa 10 ndio nilitoka town. Wakati nilikuja town, nikakuta huyu alimuona, kamwambia enda, onyesha mimi. Onyesha mimi. Nasema hivyo kwa sababu sana mimi sio mtu ya kupenda mambaya na kuona mtu akiumia. Sasa wakati nilijua ni yeye na nilienda kwake na nikamuita, akaniambia wacha niende nionyeshe nyinyi hiyo vitu nilikuwa nayo. Akaniambia betri iko wapi? Akasema hati ajui ilienda wapi, siki ilienda wapi. Kamwambia we nipe betri, mimi nitakusamea na hiyo itaishia hapa. Akakataa, na mwisho alisema alikataa. Kwa nini? Alikataa ili asipelekwe ndani. So wakati tulienda hivi nikapigia OCS simu. Kaniambia ngojea. Kuna ngali ilikuwa inakuja. Lori ikakuja. Akauliza, "Hii mambo unajua vile ilikuwa?" Akasema yeye hakujua na ajui. So ilikuwa ni lazima sasa apelekwe polisi. Wakati tulifika polisi nikamwambia we kumbali utolewe na waonyeshe mimi betri yangu mali iko, mimi sitaki kesi. Ikawa ni ngumu. Sasa kesi hapo ikaanza. Sasa mimi nikaanza kuangalia na nikaanza kutafuta namna hii kesi itaisha, kwa sababu I don't have time. Inaniharibia wakati, inaniharibia pesa. Wakati tulikuwa hivi report, tukaenda court, akapelekwa kotini hivi, ikapepa home about 1 month. Ikawa inanikula sana na ninaona mimi naumia sana. Very funny. Mimi nilikuwa kwa shamba nikasikia ninapigiwa simu na mzee Kusinga. Akaniuliza wapi? Nikamwambia niko kwa shamba. Akaniuliza unakumbuka kesi iko na hivi na hivi na hivi? Nikamwambia ninajua. Akaniuliza nikikuita tukuje tuongee unaweza kumbali? Nikamwambia nitakumbali. Akaniambia tukutane kesho asubuhi. Sasa asubuhi tulikutana na mzee. Basi nikakuta wawili. Akaniambia yeye ni mzee kutoka kotini na ametumwa aongee na mimi kama ninaweza kumbali tuongee na yeye kuhusu wizi huu ambaye nilifanyiwa, na kama ninaweza kusamea mwenye kunifanyia hivyo. Mimi nilimwambia ukweli, mimi ningependa kwa sababu inanikulia wakati na inanikulia pesa. Kuenda huko, kutoka huko mali niko, labda niko na Nairobi na mimi narudi. So wakati tuliongea hivi akanipa masiku ambaye nitakuwa na nikaenda. Nashukuru sana kwa sababu pamoja na hiyo kuna watu wanajua kuongea, na hii kikundi ni kama umefunzwa kuongea, kwa sababu wakati huu mzee aliniita
ile maongeo aliongea nilisikia ni kama hiyo kesi imeisha kwangu na haina maana tena. Na tukaenda kwa prison, wakubwa wakaitwa na kijana akaitwa. Akaambiwa sasa tuambie ukweli. Na wakati alianza kuongea akasema vile yote alifanya. Nikaulizwa, unaona utafanya nini? Nikamwambia hata hiyo vitu vingine kae, hata hiyo simu sikae, hebu anipe betri peke yake. Na awachiliwe. Akaniuliza mzee Kusinga, akaniuliza umekumbali kutoka rohoni? Nikamwambia mimi sina haja na kitu kingine. Na hapo akatuambia ile siku tulikuwa tumepewa kwenda kotini. Kaenda kotini, hakuna maneno mingi niliuliza kama nimemsamea. Nikasema ndio, na nikapewa betri yangu hiyo moja, simu zikapotea na mimi nikatosheka. Nataka kusema nini hapo mbele? Nataka kusema uzuri wa yule mzee, ile kitu alifanya ama kile mnafanya. Mnaleta hiyo both parties together, wanaongea pamoja na kile watafanya akitawatenganisha, kitawaleta pamoja na watakaa pamoja. Kijana na tunakaa pamoja. Anakuja kwangu hata baada ya hiyo namupa usaidizi. Na hiyo iliisha namna hiyo na ni rafiki yangu. Wazazi wake ni marafiki yangu. So ninashukuru sana kwa kazi ambayo mnafanya inasaidia Kenya.
Asante sana.
Thank you.
Tena ongeza kitu. Asante.
Akapelekwa kotini vile amesema. Alitumwa Kepoya prison na akakaa pale sana. Alipokuwa pale akamwona officer in charge prison Kitonga Jackson Justus, akamuuliza shida yake ni nini. Akamwambia aliiba. Akamuuliza uliiba nini? Akamwambia niliiba betri. Wakati alipomwambia hivyo, akamuita kwa ofisi. Akamuuliza uliibia nani? Akamwambia ni Kitheka. Anaishi wapi? Anaishi kwa nduka yake. Wakiwa pale Kitonga akatoka. Kaongea na Kitheka. Wakati walipoongea, Kitheka naye akaenda akakutana na wazee wa NGS. Wakakuja Kepoya ambayo ni Kusinga. Wakamuita. Wakamuuliza kama anakiri ya kwamba alikosea mzee Kitheka. Akasema ndio. Ndiposa Kitheka akamwambia amemsamea. Akamwambia ni sawa. Akarudisha shukrani kwa Kitheka ambaye ndiye complainant. Akaomba msamaha na akamsamea kutoka rohoni. Na wakafanya marafiki sana zaidi. Hata alimkozea hata wakati huo anampa kazi anafanya na anamlipa. Na anarudisha shukrani sana kwa mzee Kitheka sababu ya kumsamea. Hayo ndiyo alikuwa anataka kusema kama accused.
Asante. Lakini I think Kikamba ingeeleweka zaidi. Back to Jemima. But before I hand over the mic, all the other chiefs who had come from either Mutomo ama Isiolo, is there any other chief? Mwenye jaji introduce. Thank you so much. Back to Jemima.
Okay, bado hajapiga picha.
Yeah, so we need to take us. Yeah, okay.
Elders pia. This is our photo. Sally. This is our photo. Jacob. Jacob.
Oh, Diana, I'm being told that. Okay, so kama simu yako iko imeitishwa usikonde. Next time we'll kilicho na mwanzo lazima kiwe na mwisho. Na tunapo fika tamati, ningependa kusoma yale ambayo tumeweza kutoa katika kikao hiki as a call to action and a way forward. So I've picked 10 points which we all need to work towards. We'll be able to refine them, share them with LRF. The first one, there is need for a joint training for all stakeholders, especially duty bearers, including the magistrates, prosecutors, NPS, probation officers, PACS is the probation officer, prison officers. So we need to have a session with all these actors as we train them on AJS, as we train them on diversion, as we train them in plea bargaining. It's quite interesting that Honorable Mnyendo had to learn about plea bargaining while on duty. So we need to have a joint session. We can plan for regional sessions so that at least we have all these teams sitting together. Number 2, involvement of the communities in the implementation of the policies on alternatives to prosecution. So the communities, even the victims, can understand what do these policies talk about, what is my role, and how can I effectively be part of this implementation of the policies. Number 3, there's need to review policies and processes on alternatives to prosecution. As we've heard from our prosecutors, from the state actors and state actors, yes, you have the policies. Some of them still recommend or push us to do things that we can see are not working. So we need to see how do we review this policy so that you can have processes and that address the needs of the victims and all actors. Number 4, they need to develop a referral tool for alternative to prosecution, like what Honorable Mnyendo had suggested. I think this also came out during the plea bargaining conference, and I'll pick it up with Judge so that you can have that tool and people to see step by step what they need to do so that at the end of it all, we not have other parties sharing off the process once it's complete. Strengthen the relationship between community justice actors and the mainstream justice actors. How do we strengthen the relationship between community actors, justice actors, and the mainstream actors? So we have justice actors at the community level, the practitioners. We have those ones in mainstream, like the police, judiciary, prosecution, but also we have the community at large. How do we strengthen that relationship? Then they need to streamline human rights discourse and the application of AJS. As we heard, we still need to enhance call for human rights application when you're dealing with AJS. Addressing the human rights concerns, the human rights framework, and how do we ensure that other articles of the Constitution, such as Article 10, is adhered to the latter. Sensation of the communities and other stakeholders on the policies. So not only the community practitioners, but entire stakeholders, all the stakeholders that we have in the justice chain. Cascading the AJS models in the various prisons and courts to expand the intake. We had the example of Tumo in Kitui. Cascade it to other areas. Not only that, LRF works in Isiolo, Kitui, and now in Baringo. How do we also expand the prison model in other? Something's not working, it's also in Okay, innovation in dealing with criminal matters. How we can innovate, even at the second stage. Doesn't matter that because we need to give the AJS maybe during trial or before trial, even after the trial, and somebody still have the innovation. Don't just even what kind of the other day. This person will be guilty and they might just set them free. So that is part of innovation. Yes, you are guilty, but in terms of sentencing, then you're given an out of court sentence. So that doesn't mean that because you pleaded guilty, you must go to prison. I hope all of us follow that. Okay. Last but not least, develop framework to enhance the participation of children in the issue of juvenile justice, even as we talk about bargaining, diversion, AJS. How do we have these guidelines that guidelines that can direct us towards involving the children in alternatives to protection? So those are the 10 things that I've picked. I'll be able to discuss with the executive director, anything that I've left, and then we can be able to refine them and be the call of action on alternatives to prosecution for these conflicts. Thank you very much. So you can clap for me. Okay, because it sounds started as well, I'll give him the opportunity to just 1 minute to say something, and then I'll bring that Daktari however, ladies and gentlemen, it's all about AJS. My name is Jemima Alita. We've interacted with most of you. This face is very familiar. Kama hujaiona hii sura, haujaingia kwa hii AJS. Now today you've had the opportunity to see face to face. So if you can take a photo with me, please. Yes, on a small feet. But come on, after the photo that it is free of charge. So Twitter at the pool, but yangu is special. Now, usikuwe na haraka ya kutoka because ukishatoka hapa hakuna simu inapigwa nimekosa fare ama ni tunamalizana tu hapa na hapa. So just be patient and never request inakuja so that we sign for our transport and you go home. Don't call me and say I attended, I did what. If you are here, you sign. If you're not here, don't call. It means you are not here. Part of this session, please. After this, take tea as you wait to Sawa sawa. Sasa it's my pleasure to invite Esau, our AT. Let's clap for him.
Thank you so much. I think mine is to move on. Let's put our hands together for the good work done. Let's clap our especially one of the key things that we are spoken today, that we also need to ensure that some of the training. I've also been energized just listening. And basically engage people with the story so that they can interact and see the benefits of that. I also liked the different approaches that we had today from the bench. Judicial officers were here and also the ODPP. It's very, very important to see how we are looking at the same issues we're discussing today, alternatives to prosecutions, but basically from different vantage points. So we may need then to have similar forums so that then we are able to harmonize the varying viewpoints. The other thing again is the need for us to continue to sensitize the community and also to dispel misconceptions. Because I was very happy about the meeting today, that even where we have misconceptions, we are able to dispel them. And I thank the ODPP for coming and just sharing with us on some of the gray areas on areas that we misconceive on certain issues. I'd just like now, as I conclude, to move a vote of thanks to everyone who is here. First of all the key speakers who came before me, or the speakers who spoke today. Great speeches. We learned a lot and were very insightful. I thank them very much for that. I'd also just like to thank the panelists. We had two panel discussions. The first panel on the AJS bargaining diversion was also quite insightful and very good points that they also shared. As well as the second panelist that we also had in the afternoon. We also thank them also for their time. The second panelist that discussed alternatives to prosecution and imprisonment. We thank them. And also, like I've mentioned, we've also been very much energized by the live experiences that we've had. We've had the needs that there's still much work to be done. We had in Baringo, but we also recognize, like the member mentioned, there are 10 big counties that still need to be traversed. So as an agency, we just want to give a commitment that we're going to work with all the players who are here to ensure that we address some of the gaps that are here. And as I conclude, I just want to thank each and every one of you for coming, and thank you so much for staying until the end. Today is Friday, there are lots of things to do in this city, but we just want to thank you so much for staying until the end. That's all from my end, and unless there's any other updates we have, any other update? So we can give the special gifts and then we can proceed to have our tea. But let's give ourselves a round. Oh yeah, sorry. I sincerely apologize for that. I always I keep telling Daktari that I really love his speeches. They are blessed with humor. So please, Daktari, over to you.
Thank you. I don't have a speech now, but my brother, so let me start by thanking you as the leader of LRF. But I would like to let you know one thing. In LRF, we know good leaders by the length that staff members take. One of the few civil society organizations where staff members stay for very long, which is very good. So that is something I commend you for. So keep them. When I met her, she was still a young girl. I'm not saying she's not a girl now, but look now. Now I will talk about her because now she was a toddler when we met in Isiolo. Now this is very, very good. Please keep it up. It also shows it's a safe space young ladies, for young. That's very good. Many civil society organizations struggle with that very subject. Now, nataka kuomba vile jamaa amesema, kwa hiyo yes, kitu ya muhimu ya mwanzo ni kukuwa marafiki. Kuwa marafiki. Bishop huyu Kamilu, profesa, rafiki yangu. Nikienda huko Isiolo, nataka chakula mzuri, wao wananipangia na. Asante. Sasa na leo pia mzee, wewe nimekusikia kabisa, wewe ni mkulima na mimi ni mkulima. Nikitoka hapa mimi nataka kuwa rafiki yako, mimi ni mkulima mdogo, utakuja unifundishe moja mbili. Unaona? Asante kwa roho mzuri ile umefanya. AJS sio tu kusamea, lakini umetufundisha pia roho ya utu. Asante sana. So I want to invite all of you, ukitoka hapa vile mama anasema, usingoje tu tunangoja ati nini transport, tujuane, tuwe marafiki. Tuwe marafiki kabisa. Na wewe watu wa Baringo, msikuje siku nyingine bila kuniletea asali, unaniambia tunakuja. Si ndio rafiki huo? Kuna mtu niliwaambia hiyo hadithi wale nilifundisha last time, anaitwa Vasco da Gama. Nakumbuka story hiyo? Bas, alisema naenda wapi? India. Akaulizwa, wapi evidence? Ikabidi aende mara ya pili. Sasa wewe ukitoka hapa ili uambie watu umekuwa Nairobi, utaonyesha ile picha tulipiga pamoja, ndio evidence. Sema nimekuwa Nairobi, evidence gani? Ndio picha hii. Ndio huyu director wa LRF. Na Coast ndio huyu hapa, na Jemima ndio huyu, ni evidence. Na wewe sasa, mimi nitaambiaje watu evidence wewe umetoka Baringo? So in the future, what I'm saying, tukue nini? Rafiki. Please. Alafu ule dada yangu ametoka, Sara, aliongea vizuri sana. Ama yuko? Madam, wewe ni mwalimu. Tena wewe, I've not met you before, but I suspect you're from Nyanza. Because at some point you spoke like Nyaugenya. Which I like. Yeah, New Kenya are the ones who are very strong. But I thank you for your clarity, your firmness on matters. Even when you are wrong, you're firm. Which is very good. So now I had to, and I'm so happy you remain, because I had to respond to just one issue raised. That you said judiciary, wako kando, sisi pia watu tuko kando. Now, I now want to speak on behalf of judiciary on this particular matter. I want you to go home knowing that plea bargain, diversion, and AJS are all children of Article 159. All of them. That's a starting point. They're all children of Article 159. Either you can pick 159.1, 159.2, C is where we like taking cover, but 159.1 and 2, we are all children. So that is the beginning point. Once we agree on that, we are all children of Article 159, then the rest are details, because the rest we can discuss. So I want you to use your authority, and I really like it, to convince your colleagues. Above all, sisi wote ni watoto wa Article 159. The rest, that will be there. The last point that I want to make is, na hii ni muhimu sana, na hii nataka msikie sana nyinyi hasa AJS practitioners. Mimi nawaangalia kabisa, mimi nawaangalia sana. Naona wengine wenyu mnafikiria kukuwa AJS practitioner ni kujiuliza, je, nitaandikwa kazi na judiciary lini? Je, nitakuwa court clerk lini? Je, mtoto wangu nitamwingizaje hii kwa koti? Sasa hili swali la uhusiano lililetwa zamani sana na presbyter mmoja wa ACK nafikiria. Alikuwa anaitwa Gitari. Aliuliza uhusiano kati ya kanisa na serikali inafaa ikuwe namna gani? Alafu akajibu hivi, kuwa usiende kama mtu wa kanisa mbali sana na serikali, utakufa kwa baridi. Na tena usiende wapi karibu sana, utachomeka. Ni kama uhusiano wa mtu na moto wakati wa kipindi cha baridi. Kama hii moto ilikuwa hapa asubuhi, kuna wakati iliwaka tukasema izimwe, si ndio? Sasa Doing AJS is not equal to being incorporated in the judiciary. If you do that, we'll have lost it. That is not the intention. So the distinction kati ya court annexed mediation na AJS practitioner ni kuwa AJS practitioner wanatokelezea, jamii ndio inawatambua, wanatokelezea. Ukienda kwa bodabodas utaona wanakwambia hiyo swali uliza huyu. Sasa mimi nafanya, nikiulizwa kazi gani nafanya, zingine huwa nashindwa kusema kwa sababu kwa mahali pay slip yangu inatoka, tax yangu ya hii nchi nalipa kwa university, mimi na mwalimu. Lakini hiyo pesa ya university ni kidogo tu, na usinirekodi uambie vice chancellor nitafutwa, lakini ni kidogo. Sasa mimi ni consultant, si consultant, mimi si hustler, hapana. Mimi ni consultant senior kabisa. Saa hii ile consultancy kubwa nafanya, mimi naangalia migration ya wanawake kutoka hapa Niger, Senegal, Cote d'Ivoire, Mauritania, na siongei French, na wanaongea French, lakini mimi ndio nafanya hiyo route yote. Na wakati tunafanya hiyo research, ile kitu kubwa sana nimeona ni kuwa watu wanapenda uongozi, hata hao wanawake ambao wanafanya migration. Kuna kiongozi anatokelezea in that misery. Huyo kiongozi anaheshimiwa kuliko kiongozi wa serikali. Na hiyo uhuru ya wao kupata kiongozi hapo inawapatia nguvu ya kujitetea. Kwa hivyo AJS chembe yake ni hiyo, kupata hiyo nguvu. That's why article 1 inasema sovereign authority inatoka kwa watu. 159(1) inasema judicial authority inatoka wapi? Kwa watu. Hata executive authority inatoka wapi? Kwa watu. Hata hiyo legislative authority inatoka wapi? Kwa watu. So don't struggle to be too close. Now, court annexed mediator lazima koti imchambue, ajue amesoma nini, alafu aandikwe kwenye kitabu ya koti afanye kazi. Hiyo skill ni muhimu, lakini usiruke huko. Retain the autonomy. Finally, I really want to thank Jemima. This Jemima, you don't know. This Jemima used to work for ODPP with her. Then she came one day. Those days she used to put on red suits. Mimi nataka kutoka hiyo. Mwambie ukitoka Jemima, usiende mbali na mimi. Akatoka. So when we were appointed for the second term, alikuwa kwa task force. So she is not just head of secretariat. When the history of AJS is written, as it's being written now, she was in the task force that developed policy. So I went to look for her, and I gave her free tea at Crown Plaza Hotel. That time, you see the work the member has done today, that work used to be done by myself and the Sisungudi. The entire country. Free. So these days we thank her that I can go in, go out. She can hold forth, and she can also, not she can, she has also become a teacher. Thank you, Jemima, for the good work. I can tell you that on the last day, Tarumbeta Ikilia, your name will be in the book of life. Amen. So let us give another applause. Let's continue this, and thank you for the sacrifice and innovation. The more we have candles of AJS lit, the better for our country. So the more candles you can light. Kesho tena tulikuwa na wengine na watoto. The other day we were with another group and so on. The more candles. I ask that we keep well. May God bless us as we go on, and may we continue being members of this movement. Na nikisema AJS, mnasema haki mashinani. AJS, haki mashinani. AJS, haki mashinani. Asanteni sana.
Okay, so on behalf of the boy child, I'd like to present again to Daktari. Daktari has worked this AJS, as I said earlier. At least today hakupata nini Valentine's gift, but at least we are giving her a gift. Karibu daktari. Idi, please kuja umpatie ndo asienda apige picha alafu aulize who was that beautiful girl.
You sit here now. Okay. I didn't know you're beautiful, but now you know. Thank you. Thank you. And today is my daughter's birthday, so I'm going to give this to her. Oh, happy birthday to her. Thank you.
Okay, Vanessa, please, we need to appreciate our champion, Honorable Mnyendo. Let's clap for her. Okay, thank you. Madam Sarah Green. Karibu. Let's clap for her. As I said, nilikuwa natafuta kwake kwa supply. Kwa University of Nairobi, they don't give you a for supply. Thank you so much.
Thank you.
Yes, Endless, on behalf of Endless.
Thank you.
Hey. Okay, hata mimi pia nitapiga picha. So, daktari usikae na wivu.
I'm the one who should be giving you. Oh, so why not? Please. Okay. Let's be now. Let's give the line now.
Oh, sorry.
Come closer.
Thank you so much. Thank you so much. Bishop, please bless us the word of prayer.
Tusimame. Tushukuru. Mwenyezi Mungu Baba wetu, tunakushukuru kwa muda ambao tumekuwa hapa. Tunapopumukana kwenda makwetu, tunaomba roho ya umoja, roho ya haki na usawa masinani iendelee kuwa pamoja nasi, iendelea kusaidia jamii kupata haki. Mungu wetu, tunaomba kwamba tutaendelea kuwapa kibali wafadhili wetu, ili so that they may find favor in whichever office they will knock on our behalf, ili wapate ufadhili ya kutusaidia kufanya kazi hiyo. Asante kwa the commission, the tax force ile ambao pia imeendelea kufanya kazi hiyo, kuhakikisha kwamba imenakiliwa kwa sheria ili iweze kufanya kazi na kutengeneza frameworks zile zinahitajika ku operationalize na kuboresha mambo haya katika sehemu zetu. Kushukuru kwa ajili ya Jemima na watu wa serikali, judiciary team, wazee wa jamii walio hapa, wadau wote. Mungu wetu, tunakushukuru kwa umoja huu, na tukiomba kwamba endelea kutupa hekima na maarifa wa kuboresha mambo haya kwa utukufu wa jina lako. Tunapo sasa pumkana, endelea na kila mmoja wetu, tupeleke pakwetu kwa ulinzi wako mwema, ufunike vyombo vyote tutakavyotumia kusafiri na damu ya Yesu, maana tunaomba na kuamini kwa jina la Mungu Baba, Mwana na Roho Mtakatifu. Amen.
So we can serve some tea as we organize ourselves. Jeff,
Hello.
please. Yeah?
Oh,
We are
wanasema tu uende.
waiting for your directions.
Salamu ya kansa mwambie kuja kupotea. Wacha nikuletee huyo kansa. Madam jana anaitwanga ndani. Wacha nimuulize jina yake na kumwambia. Haya.
sorry. I was able to say hi.
Oh.
Hello.
Hello.
Mambo.